Morning, Julie. Hi, Jane. Colin, Michael.
Good morning.
Good morning.
Can I ask you guys a quick question? I have pinned on my screen people. Is your view still full gallery, or do you see the pinned view as well?
It's
Full gallery.
Okay. That's unfortunate, but I will see what I can do about that.
Morning.
Morning. Commissioner David, we can hear you, but we cannot see you. Oh, there you are. We're just missing Commissioner Douglas, it looks like.
Is Mark not coming in?
He's
So
here.
he's on the screen.
I see him. Hi, Mark.
Did that change the view to you guys seeing just the pinned people?
Nope.
Okay, well, it's 8:31, so I'll let people in. I'll fiddle with that as we go.
Okay. Commissioner Whitman and Commissioner Douglas, I see your digital presence, but not your physical presence. There we go. Commissioner David, I think we're good when you're ready.
Okay. Give me just a second to get to my my cases for 2026. All right. Oh, a lot of people showed up there. Or you changed the setting or something. Good morning, folks. My name's Ed David, and on behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking you, each of you who may have an electronic device, cell phone, pager, etc., to ensure that they are silenced now. We have additional agendas online, and including the consent agenda. And the consent agenda is a listing of cases in which no written arguments were made to the commission. In the allotted time, the commission will vote on those cases, and they will not be considered further today because there's been no response filed. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda, As I call each case, the party who has submitted a written argument will be called and recognized online to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes for your presentation may not be exceeded. Procedural rules of the commission specify that your arguments may address only one, relevant factual errors, two, relevant omissions from the report of facts submitted from the investigator, and three, relevant issues and questions concerning interpretation of law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposing party. Please be advised that the commissioners may ask questions. I will ask you to introduce yourselves as you come to the podium. First order of business will be to ask, are there any proposed amendments to the agenda? And then we will consider adopting the agenda as published. Colin?
The only possible amendment to the agenda, now I gotta find the case. No, I can't find it. Do you remember which case it was that the complainant had submitted a withdrawal request?
Colin, Jane just sent an email. It's H230461.
0461.
Nope, Michael, that's conciliation dismissal.
Okay, gotcha.
It's the first case on the agenda.
Oh,
So the first case, E230448, is considering a conciliation agreement, or is it a hearing case?
I'm sorry. Let me look this up real quick. Thought I had written this down. It was H250302. There it is. Okay, so that's Alice Beckett v. Joyce Jewell, Delaney Gillinis, and Larry Fowler.
So that's not for hearing, that's for consideration of an agreement?
Withdrawal. Yes, Commissioner David. So typically, so the withdrawal came in late, request came in late last week. Typically, it's up to the executive director to recommend to the commissioners whether or not to approve the
Correct.
withdrawal or to go on with the case. Obviously, the executive director is not here today, but typically the executive director recommends that you do not approve the withdrawal because of the resources that have gone into the case from our point of view. So with that
Correct.
in mind, I guess we'd be looking for a motion on whether to accept the withdrawal request or not.
Okay, I will move to not, and that's well stated, Attorney Hurd. We typically do not accept last minute withdrawals because of the resources that have been devoted to it and the possibility of public interest in the case. So I will make a motion that we deny the request for withdrawal in H250302 A, B, and C. And then we'll adopt the agenda with that amendment, depending on what happens to that motion.
Is there a second? Commissioners reminded to visually and audibly give their votes.
Second.
Thank you, Commissioner O'Brien.
One quick question, Attorney Hurd. Are there any extenuating circumstances that the party requesting the withdrawal noted in the request?
The only justification that I recall her giving is that she was just done with the case and didn't want to deal with the respondents anymore.
Okay, thank you. I also want to note as well, I see a hand up, Leanne Messina, Gaslight Harmonies. Is your hand up relevant to this particular matter that the commissioners are now discussing?
Commissioner Sanders, I'm going to jump in. She's a complainant in one of the
Okay.
cases that's coming up later.
Okay, simple request to remove the hand up then, just for clarity for the commissioner's sake.
Is there any more discussion about the withdrawal request? for H 250302? Okay, seeing none, the motion is to deny the withdrawal request, and we'll go in order of seniority. So yes vote would be to withdraw the request. So Commissioner David,
Yes.
Commissioner O'Brien,
Yes.
Commissioner Whitman,
What?
is he here?
Walker?
Commissioner Walker, I think you
Walker.
mean, yeah.
Sorry about that, Commissioner Walker. Commissioner Douglas,
Yes.
Commissioner Walker, I didn't actually get your vote.
Yes.
Okay, thank you. Commissioner Sanders.
Yes.
Okay.
Right. So
I thought
we
we
will
were
consider.
promoting Michael there for a minute.
I know. Is it
We
a
will-
promotion though, really?
I like it. It's probably
will
a
con-
decrease in pay.
We will consider the agenda as amended by the deletion of that. No, we will consider the agenda as published without amendment. So before us is the agenda for the January 5th meeting. Be appropriate to hear a motion for adoption.
So, yeah. Second.
Okay. Any discussion? Seeing none. If you're in agreement, you will vote yes. And again, remote participation policy requires commissioners to indicate their vote audibly and visually. So Commissioner David,
Yes.
Commissioner O'Brien,
Yes.
Commissioner Walker,
Yes.
Commissioner Douglas,
Yes.
and Commissioner Sanders.
Yes.
Okay.
And you have before you the minutes of the December commission meeting. We have the written minutes. The on the floor would be a motion, would be entertaining a motion to adopt those minutes. Do I hear such a motion? I've read them
So-
and they appear correct.
So moved.
Second.
Okay. Any discussion? Seeing none, if you are in agreement, you will vote yes. Commissioner David,
Yes.
Commissioner O'Brien,
Yes.
Commissioner Walker.
I have to recuse myself. I was absent.
Right. Thank you. Commissioner Douglas
Yes.
and Commissioner Sanders.
Yes.
The next item of business will be the director's report. Deputy Counsel Hurd is running the meeting in the absence of Kit. And Colin, you prepared to run through those reports?
Yeah. Yes. Okay, so personnel, there was a report placed on file for compliance. Since the last meeting, there have been, well, no conciliations have taken place since the last meeting, so nothing successful or unsuccessful. There's still 6 reasonable grounds findings that are pending in the active conciliation queue. We had 53 new complaints filed in November with a total of 74 new respondents. Withdrawals and dismissals, there were 32 issued in November, including 15 ADs, 3 right to sues, and 12 settlements, 4 of which were after MHRC investigation, and 2 were through the MHRC mediation program, and 6 were private settlements, with a total of $163,986 to complainant. One quick note on personnel, we did lose one employee. She resigned on her own on December 12th of last year, and it was amicable. And the last thing is Jane's requests to dismiss H230461, and that's in the memo, the conciliation memo in the drive. So you should have access to that.
We do we do have access to that memo recommending dismissal for Young versus Pines Senior Community recommends dismissal because of compliance, including the monitoring. Let's take that up now. I would move to dismiss that case based on the agreement.
Is there a second?
Second.
Okay. Any discussion? Okay, seeing none, a yes vote will agree with the motion to withdraw the case previously mentioned. So Commissioner David,
Yes.
Commissioner O'Brien,
Yes.
Commissioner Walker,
Yes.
Commissioner Douglas,
Yes.
and Commissioner Sanders.
Yes.
Okay. And with that, see the time is 8:44. Commissioner David, do you want to just get going, or what are your thoughts?
Yeah. So you finished with the business report?
Yeah, we have no new business at this time, except to state what you've already stated is that the executive director could not be here today, so I'm filling in. So
Right.
please forgive me in advance for any hiccups along the way.
Okay, and I think we're exactly on time for 8:45 for the beginning of the hearing agenda. I will call the cases and indicate who speaks first. Before doing that, Attorney Hurd has some general instructions for the litigants in terms of time and reserving time and that kind of thing, Colin.
Yes, and then real quick before we get going too, I want to remind everybody that's here that the Maine Human Rights Act requires that names of third parties remain confidential. So please do not use the names of persons or entities who are not named parties to the case. The reports that were written should include pseudonyms. So make sure when you're giving your case today that you only use the pseudonyms from the report or the person's title or relationship to the complainant. Okay, so the first case.
And you're timing
Yes.
and allowing people to reserve time, right?
Correct. So for the first case is Pelletier. So Miss Pelletier, are you present?
Yes.
Yes. First case is E230448, Pelletier versus a Rustic action. The recommendation from the investigator is for a recommendation to the commission is for a finding of no reasonable grounds on both counts, sexual discrimination and WPA retaliation. And since the recommendation is for a finding of no reasonable grounds, we will therefore hear from the complainant first.
Miss Pelletier, sorry, am I pronouncing your name correctly? Is it Pelletier?
Pelletier.
Pelletier, okay. Well, you have 10 minutes. Do you want to reserve any time of that at the end, or do you just want to go?
I guess I'll reserve some of that time at the end just in case. I don't really know. I've never.
That's fair. So you'll have 10 minutes, and then whenever you stop, you'll have whatever time is remaining. Is that okay?
Okay.
Okay, you may begin when you're ready.
So I'm just supposed to say why I don't agree with the findings. Is that all?
Yes.
Okay. So I did file my response to the report, and just that the commission didn't have it correct what I was even filing for. So initially, I filed the complaint for discrimination in the workplace of sex. So there was a coach that was a male that was hired at the time I was a coach at ACAP. So for the same position that I was in, at a much higher rate of pay with less education and less experience than me or any of my coworkers at the time. In the report, it is that I filed against that suit for him being hired as my manager, which that happened after the fact. He was promoted later, but I'm filing for when he was hired. He was hired at like $8 and something more an hour than me or any of my coworkers. So that was what I was filing for, and so that was wrong in the report. I don't know what else to say about that other than that. And I have proof of all of that and my education, anyway. So I don't know what I'm supposed to really say more about that, I guess. And then what else did I disagree with? Then for the reasons that I was fired. So I filed for the Whistleblowers Act. There, that's what it's called. And that I was fired because of I told on a leadership person at ACAP, me and two other coworkers. And after that, it was very obvious to all of us that we were targets from leadership. And it's hard to prove that though, because they obviously say the opposite. But that's why I was fired. There was never anything bad on my record or anything at all until that happened. And then after that date, it was just all bad for me. And I worked really hard when I was at ACAP and I did my job very well. There was no reason for me to be fired other than that I knew too much about what was going on in leadership. And it was never investigated. It was never looked into even what we reported on. And instead, me and both of the coworkers that made this report on the leadership person all no longer work there. One employee was there for 28 years and she resigned after that because of how toxic the environment got. The other coworker also got done and found a new job too because of the toxic environment and the targets we felt like we had on our backs. But it's really hard to prove that too, because I don't have access to their files or to who they told or what they told, but I know that she knew exactly who told on her, even though we were supposed to be protected. The reasons that I was fired, one of the reasons that I was fired was a complaint that was filed with leadership that I believe is in the report. It's one of the things that ACAP submitted. And if you look at the date on that statement about my misconduct at an event that I did, the event that was about was 5 months prior to that statement being filed. So the event that I did with this other ACAP employee was 5 months prior to when he filed this statement, which just happened to be the day before I got fired. So he filed it on August 10th, and I got fired on August 11th. About a situation that happened 5 months prior that I never heard anything about ever until I got this report back from me filing my complaint with the commission. So I feel as though that like that, I don't understand how that happens, how they just make up a reason and add it in the day before I got fired. They like looked for something to fire me for. And the other reason was for attendance or saying things to my coworkers about how I felt about leadership and things that were happening, which I didn't know you're not allowed to say how you feel about what's going on in your situation. But I don't know how to prove anything more than what I've already sent in, I guess. So are they questions? Are questions going to come to me? Is that happening?
Yeah, if you're finished, the commissioners can ask you questions, and then whatever time you have left, we'll come back to you after that.
Okay. Sure.
After the respondent goes. Are you finished?
Yeah, sure.
Okay. So questions for the complainant. Commissioner O'Brien, I saw your hand first.
Hi, good morning. Have a couple questions, and one, I'm not sure in reading the case before the meeting. I'm not. I keep going after it. I keep reading it over and over to see. I don't know if it was written wrong or. Let me read what it says in one of the investigators report. Soon after the complainant was hired, she learned from a male coworker client whom she was dating that he was just ending a physical relationship with director. Did I read that right? So go ahead.
Yeah. So, okay. When I got hired at ACAP, I was hired by the director of programs who was involved in this situation. And then found out weeks after the fact of being hired from a man that I was seeing now that I met after I started at ACAP, that they had had a relationship up until that point. And she also was his social worker before that. He was staying in the shelter that ACAP was putting on or whatever. So she's a licensed social worker. She was his social worker. And then was in a physical relationship with him as a social worker, and then hired him as an employee, promoted him, and then fired him. That's all irrelevant, I guess, to this, but yes, you read that right.
Okay, and I had one other, I wanted your response, if you can give it, about the team goals. It was supposed to be 5, I believe, and you had 2.9, and this paragraph says that when you were spoken to or emailed about that, you didn't respond.
I responded to the first email that he sent.
Okay.
And then the second email, I didn't think that there was anything that I needed to respond to that. I already had responded to the first one. They didn't include that.
Okay.
There's a lot of stuff they didn't include that should have been, but
Okay. And are you disputing that your output was probably half of what they wanted?
so what I will say is that prior to that email, we never had any goal of 5 contacts a day. That was from that email. That was when that started. That was when we were told that that was a goal. Like, that was made up right then. So we never had that before. And what I will also say about that is I worked under several programs, not just one program and not just one database that we kept documentation on. I worked under 3 different databases, and that was only one database of which he got that information from. So not including any of the other work that I did with families, I at the time had the largest caseload of any coach. I was the only coach in Presque Isle because we were down a coach. And the coach that I'm filing against, that was hired at a much rate of pay than me, was supposed to be my coworker that was taking on half of my caseload. I was training him the day before he got promoted. But so yes, I'm disputing that because that doesn't do any justice to what work I was doing. That's just part of it. And they made it seem like that was all of it.
All right. Thank you for responding. Thanks.
Commissioner David, I saw your hand earlier. Do you still have a question?
Yes. Good morning, Ms. Pelletier. You mentioned in your presentation the complaint about your behavior at the event, which is described as a job fair in the report. I hear you saying that the filing in your, I guess, in your personnel file of the complaints about that was late, but are you disagreeing that the content is appropriate? In other words, what it says about your behavior is fairly serious for a job fair, for you to be saying to people that you're looking for another position, the workload is unacceptable, that kind of thing. So my question is, can you direct, can you inform me as to your position about your behavior at that event, aside from when it was documented in the file, which may have been papering the file because they're putting together all the evidence? I mean, that's a question that we'll ask the investigator and the counsel for the respondent.
So what the statement said was that I brought chairs that were inappropriate and not professional. That was one of the parts of it. And I brought 2 chairs that I had in my vehicle from my garage, like camp chairs. We always brought chairs like that to events. And what I didn't know, like, I wasn't going to carry 2 metal chairs that I had to bring into the mall. It was in the mall in Presque Isle. So I had to carry all the stuff in and then carry it out. And I brought the person who filed the complaint a chair as well. Regardless, I never once spoke to any person at the job fair about anything negative about ACAP. The only person that I spoke to about anything at all and venting about my situation was my coworker, and nobody else heard any of that. That had nothing to do with the job fair. The job fair was successful. I did well with talking to any client there, any person that came up and wanted to know more about programs at ACAP. I was very kind and professional. I always was professional with any clients that came to talk to me about anything.
He says in the report that you referred to your supervisor with a with a sexually disparaging epithet, calling her a nasty bee.
That was about his supervisor actually in that, not my supervisor.
Oh, okay.
Yep, and he said the same thing. This was a conversation between the two of us about how we felt about stressors at work, and then it turned into just me saying things, and that's not true. Um, that's not true. I don't.
Another question I had, paragraph G in the investigator's report says that you noted that they hired a female coach being paid $303.40 an hour higher than you. How is that sex discrimination?
That's not. That was just like more just proof of that things are not right as far as how they treat people, but that doesn't have anything to do with the coach that they hired. I guess it shouldn't have been included, maybe. We were being discriminated against after we filed that complaint with leadership,
Who's
and they
we?
started me and two other coworkers that made the complaint. It wasn't just me, I guess, involved in this, and I tried to have them included in it, and as witnesses they wrote statements for this too. I don't, they just weren't included. I guess it was his choice not to include them.
And I mean, I hear you saying that things were just not right at the at the employer. Your burden is to show that there was unlawful sex discrimination or retaliation for reporting the affair. You feel you've
Right.
met that burden?
So what I'll say is I don't know how to give proof of things that I don't have access to. Only they had access. As the day that I was fired, they took away all my access to any of my emails or reports or anything at all, even my evaluations from each year to show the work that I did. I didn't have access to any of that, and they only shared what they thought they should, which didn't look good for me. So it's just not fair. But I guess I did my best. That's all I could do
Thank
to
you.
prove my case. Yeah.
Okay, Commissioner Sanders.
Great, thank you. Good morning, Ms. Pelletier. A couple of questions for you. On page 2 of the investigator's report, there's a numbered paragraph D indicating that in addition to the performance concerns that we've discussed, you also arrived late or left early over 6 times between February 10th and March 23rd. Is that correct from your perspective or incorrect?
So we had flexible schedules at ACAP. We were told when we were hired that as long as you did your 8 hours a day or 40 hours a week, it didn't matter if you came in at this time and left at 9 p.m. And then all of a sudden, it switched from that to saying we needed to be here at this time. And I had never heard anything about attendance issues for me at all. And some of that is incorrect about leaving early or coming in late. It's just not right. I was in my own office space. I had my own building that I went to every day. So he wouldn't have even known that I was late or not, which I wasn't.
When were you notified of the changing expectation? I think I heard you say that at some point the expectations changed. When was that, if you recall?
I don't know the exact date of when that happened, but it was close to around the time that he was promoted to the program manager. So around January of that year.
Okay. If you were told then in January of the changing expectation, I'm curious about, the investigator's report reflects that, there was a late arrival or an early departure between February 10th and March 23rd. So I'm curious, you would have been on notice, right, during that time frame of the expectations for punctuality, correct?
Correct. And so the couple times that I was late, my program manager knew. I was in contact with him the whole time. I had a flat tire one morning. I mean, there's nothing you can do about that other than to just try to get it back up and running and head to work. And then also leaving early. I was sick one afternoon, and then it was a really toxic work environment to be in. And I had earned time that I used during that time, not just leaving early and not doing my job. I used my earned time. That's what that's there for.
Okay.
So
I want to fast forward to the exchange that you had with Commissioner David about the circumstances relating to the job fair. I think I heard you say during your exchange with Commissioner David that at all times during that job fair, you believed that you were kind and professional. I'm curious about that, right? I think I heard you say that you and a colleague were exchanging comments or having a conversation, which include this sort of, um, this comment or epithet that's tied to sex-based characteristics. Do you, so I'm curious if you can harmonize those two things for me. How could you be kind and professional if you acknowledge that, in fact, you use that phrase?
I can't say that I used that phrase exactly. That, like I said, that statement came out 5 months after that
Okay.
event even happened, and I didn't even know anything about it. They never
You,
mentioned one thing to me about
you
my
can't,
content.
you can't say, I'm just going to press you a
There
little
was
bit.
no one
You can't
around.
say, you can't say that you use that phrase, or are you representing here today that you did not, in fact, use that
I did
expression?
never say that I used that phrase. I never said that I said that, but I did say that he said that. I mean, that is something. It, yeah.
Okay, but you didn't answer my question though. Are you saying here today that you, in fact, did not use that expression? And so, in other words, that colleague of yours is lying about your use of that expression?
I do think that he is not being truthful. Yes.
Okay,
Um, and did anybody else hear that conversation between him and I? No. There
okay,
was nobody. The job fair was really slow. There was only a few people in there at a
okay,
time throughout the day, and there was no one around when we had that conversation.
okay. Um, the fact remains, though, that you can't say with, sort of certainty that nobody overheard you make these comments or overheard this discussion, right? That's not a realistic representation you can make, though.
I sure, I guess. I
Okay.
don't know.
Okay, thanks.
Are there any other commissioner questions? Okay, seeing none, Ms. Pelletier, you'll have 5 minutes when we come back to you. And then I have Attorney Newell for the respondent. You have 10 minutes. Did you want to reserve any time, Attorney Newell?
I would like to reserve 3 minutes, although I probably won't. Knowing me, I probably won't even use all of it, but
Just give me 1 second. Okay, whenever you're ready, begin.
thank you so much. Good morning, everybody. I represent ACAP, and I know you've read, I know this commission is very good at reading the information in the pleadings. I don't just want to repeat everything. I will say about ACAP, I'm proud to represent them. They are one of the state's community action programs, which, as people probably know, is really one of the state's great treasures. They serve people in all sorts of ways, including education and heating assistance and case management. And in this case, the employee in question was coaching individuals and was, part of doing really important work in the state. I will say I was surprised at the disagreement and surprised by Ms. Pelletier's presentation today, indicating that, the investigator had focused on the wrong things. If you look at the complaint, it's very clear that the complaint itself was about a failure to promote, that was the main crux of the sex discrimination claim. And about whistleblower retaliation based on this complaint about a program director. And that is exactly what the investigator focused on here. There was an allegation in the complaint that Ms. Pelletier had made a complaint about male coaches having higher wages. But in her complaint, she makes clear that that was done via an email on May 11th, 2023. And ACAP produced that email, and that email had nothing to do with male coaches. It did complain about pay, but focused on another female coach that was paid more. So there was no evidence that complainant had made complaints about male coaches being paid more, although there was, there was evidence that there were issues with, that complainant had issues with her pay. It was never alleged that it was sex discrimination until the complaint was filed. And then even when the complaint was filed, it was based on erroneous, erroneous information. To get to, of course, we are in agreement with the investigator's decision. It seems that most of the questions of the commission were focused on this job fair. I will note that the interactions that complainant had were based on two incidents. One was the job fair, and another was an incident with that had occurred just before the termination on August 7th, where complainant had been working with a new employee training her and had been so negative about the agency that the new employee was very uncomfortable and had made a complaint to leadership about it. And so those were two incidents that occurred, and that, along with the job fair where the complainant made the comment about an ACAP supervisor, not her supervisor, but one of the supervisors at ACAP. Those were, the investigator, I think, correctly determined that those were legitimate reasons to terminate Ms. Pelletier's employment, and that the termination of her employment were based on those reasons, along with the performance issues that she had been having, which, are well documented in terms of email in the case, in terms of emails between herself and her supervisor and other people in leadership at ACAP. And even now you can see Ms. Pelletier doesn't accept sort of those issues, but they were present. And so that the investigator found that there were legitimate non-discriminatory reasons for the termination. I will note, with regard to the complaint that was made that Ms. Pelletier believes was the basis for retaliatory termination. That complaint was made more than a little more than 6 months before Ms. Pelletier's termination. So it would be unusual to wait that long to retaliate against an employee, I would think. In addition, the employee who the complaint was made about had nothing to do with the termination. The termination was, she was not a decision maker, and the investigator determined that as part of their investigation report. So in addition, you heard Ms. Pelletier herself say there were two other employees who were involved who were not terminated. They went on and resigned at some later point, resigned their employment on their own to move on to different employment. But they were not terminated or retaliated against in any way. So the investigator's decision is, I would say, spot on. There was not discrimination based on sex, and Ms. Pelletier was not retaliated against.
Okay, thank you. Are there any questions for respondent's attorney? Okay, seeing none, you will have
just one.
Oh,
Attorney
sorry,
Hurd. Yeah.
Commissioner Sanders.
Thank you. Attorney Newell, just one quick clarifying question. You indicated that with respect to the epithet that Ms. Pelletier and her colleague used at the job fair, that was 6 months or so prior to the time of Ms. Pelletier's termination. Is that right?
No, I indicated that her complaint about the program director, which she claims was the basis for retaliation, was 6 months prior.
Okay.
The job fair, I don't seem to have the date of when the job fair was, but that was brought to the attention. This other incident.
Attorney Newell, you froze for a moment as you were answering the question. Could you repeat your last part?
Sure. I turned my video off in case I'm having some
Sure.
connectivity problems, so I'm sorry. Yeah, so no, I was indicating that 6 months prior to that was when she made the complaint about the program director that she claims is the basis for the retaliation. In terms of the job fair, I'm looking to see, I don't know off the top of my head what the date of that job fair was, but I can look as we talk to see if I can figure that out.
Sure. It may not end up mattering. I'm just curious about at the time of the job fair itself, was the employer on notice that this conversation happened, or what did that only come to light closer in time to Ms. Pelletier's termination?
I believe it came to light closer in time to Ms. Pelletier's termination.
Okay, and so otherwise, prior to that, the employer was not on notice?
I believe that's correct.
Okay, thank you.
Okay, any other questions for respondent's attorney? Okay, seeing none, you'll have 4 minutes and 23 seconds when we come back to you.
Thank you.
And Ms. Pelletier, if you're still there, you have 5 minutes left if there's anything else you wanted to add to your previous presentation.
I guess I don't know what to say. I've done what I could to prove what I'm saying, and what I will say is that I did my job at ACAP well. There was never anything wrong with my performance or anything on my record. Nothing happened. And then all of a sudden, and the other two employees that made this complaint with me to leadership about the director, they got done before they got fired, because they knew that that was what was going to be happening, because we all knew that that was what was coming. But so ACAP hired me as a second chance for me in my life at the time. I needed it, and I knew Heidi. We went to high school together. Sorry, I used the name. We went to high school together, and she hired me because she knew I was a good social worker. I performed so well at ACAP, and I was included on so many different projects and took on all kinds of things for them. I had an overloaded caseload. Then to just be terminated like this for reasons that are ridiculous, in my opinion, because I did my job well. And nothing ever was said about my performance or anything like that until after that file was made with leadership about the director. And it took away my second chance for no reason as to me. And this is all just really not fair. And I don't know how to prove it otherwise, but that's all I have to say.
Okay, thank you. Any other commissioner questions? Commissioner David.
Yeah, Ms. Pelletier, you just said that in regards to the report, as I understand it, this is a report that the director was having an affair with a colleague. Is there are you saying that there's any direct mention of that after making that report? I mean, well, first of all, when is that report in regards to you being terminated? You said it was 6 months before.
It wasn't 6 months before. I don't know the exact date. So it was after he was hired. So it was after January. It was not very long before I was fired, I don't think. I don't know the exact date. I'd have to get into my files and look. But
are you saying that anybody says anything about it to you? Oh, you're in trouble. You're telling tales about the director. He's going to be upset about that. They'll get you for that. Are you alleging any any retaliation?
I was fired because I made that report. That's the retaliation.
Right. And you're saying you're fired because you made that report. It's the because. Prove it. Where is the evidence? Yeah, okay. I hear you. All right.
I don't know how to. I mean, other than what I like, they did not include the things that should have been included for my personnel record to prove that of what I did when I was there. I did a kick butt employee for them and went above and beyond, volunteered my time, did everything I needed to, and it doesn't show that. And I don't know how to prove it.
Okay.
Any other questions? Commissioner questions? Okay, seeing none. Attorney Newell, you have 4 minutes and 23 seconds if there's anything else you wanted to add.
I don't have much to add. I will just say the report was made on February 27th, 2023, and Ms. Pelletier was terminated on August 11th. So it was just short of 6 months prior to. And there was no evidence between that time and Ms. Pelletier's termination that indicated that there were any problems with Ms. Pelletier having made that report. And during the fact finding, Ms. Pelletier did indicate that there was no evidence that had occurred, that it was just what she believed had happened. So those are the only additional comments that I'll make at this time.
Okay, and any additional questions for Attorney Newell from the commissioners? Okay, seeing none, thank you both. Next, we'll hear from the investigator in this case, Bob Bouchane. Bob?
Thank you. I really have very little to add here. I think, again, the sequence of the events did reflect that the report about the supervisor did come quite a bit before the incidents that allegedly led to her discharge. I didn't see any link between that report and the ultimate discharge itself. While I agree that one of the events did occur several months prior to the discharge, that doesn't mean that it was not factually presented. While she may disagree with whether she used particular term in question, she does not dispute that she was speaking poorly about the agency as well as poorly about supervisors. In my mind, that was enough in and of itself for her to be discharged, albeit a lesser level of discipline may have been effective as well. But that's not really my concern. It was simply whether she was able to establish a link between the report about the supervisor and the discharge. And in this case, I just didn't see that as a plausible or approvable connection.
Okay, thank you, Bob. Are any commissioner questions for the investigator? Commissioner David.
Yeah, Bob, thank you for the report. I can understand, and I think I am convinced by what you just said in terms of your conclusion about the report being months before the discharge and not showing any causal connection there. It's the kind of thing that you would think that if that were a motivation, that she's saying that the director's having an affair and he or she was going to retaliate, that it would have come quickly. I am a little more concerned about the pay discrimination and hiring that coworker that then gets promoted to be her manager. Can you review those facts for me and why your conclusion was that there was not a discriminatory operation going on there?
Certainly. I guess, first of all, the agency had represented that it was in the process of reviewing rates of pay for all employees at that time. And they indicated that this individual was hired as a male coach, and that was primarily because he had an excellent interview and presented a lot of new ideas as far as what he could bring to the company, which may also explain his higher rate of pay. So in this case, even after there was a complaint about the comparable levels of pay, they apparently looked into it and did raise a substantial number of other salaries for employees as well. So again, while it's not disputed that he was hired as a higher rate of pay as a coach, that was a couple of years after complainant was hired. So whether or not her pay kept up with what he was paid, again, I had nothing to suggest that, excuse me, that it was his sex or her sex that was the determining factor in the rates of pay.
It was a couple of years later?
She was hired, I believe, in 2021. He was hired in January of 2023.
Thank you.
Any other commissioner questions for the investigator? Okay, seeing none, thank you, Bob. So you've heard from the parties and the investigator. At this time, we'd be looking for a motion. There are two proposed findings, both for no reasonable grounds. there any motions?
Yeah, I'll move that we adopt the investigators' findings. I'd move to take them together. That there are no reasonable grounds to believe that Aroostook County Action Program retaliated against Mr. Pelletier for engaging in WPA protected activity, and there are no reasonable grounds to believe that ACAP discriminated against her on the basis of sex.
Do we have a second?
Second.
Commissioner Sanders. Any discussion? Commissioner David.
Yeah, I'll be voting in favor. As I observed with Bob, it's pretty clear that there's no retaliation around the complaint about the affair, and I need to yield to my investigators' conclusions about the wages. She indicates that she's upset with a number of small things, but she has not fulfilled, to my mind, the burden to show that those reasons, some of which are clearly substantial on their face in terms of attendance and bad talking and public running down at the job fair and that kind of thing, are a pretext, which, as I understand it, is what her burden would need to be.
I agree with Commissioner David. I'll be voting yes as well. I share the same observations that he has with respect to the pay discrepancy, to the extent that there is one. That's something, certainly the respondent here, to the extent they haven't fully investigated with an appropriate look back period, investigated and corrected discrepancy in pay. That's certainly something this employer and every employer needs to do. So I just wanted to echo and highlight very specifically this issue of possible or alleged pay discrepancy.
Yeah, I would just briefly add, I'm in complete agreement with the other commissioners here, Commissioner David and Commissioner Sanders. In addition, I would just say to the complainant, I understand where you're coming from. I mean, basically, what I hear you saying is you feel you were not treated well at this job, and I want you to know that I understand and I appreciate that. I think where your complaint fails is that you've alleged, a whistleblower protection act claim and a sex discrimination claim, and there's just very little evidence of that. And as you said, you don't know how to prove it, and I'm sympathetic to that as well, but there's just not enough proof on this record for us to find in your favor today.
Okay. So the motion on the table is to find no reasonable grounds. If in agreement, you will vote on both counts. If in agreement, you will vote yes. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker. Commissioner Walker, sorry, I got to hear you as well. You're muted.
Yes.
Thank you. Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
And we'll you want to indicate what the commission does, Colin? You send a letter?
Yes. So the commission will send a letter to both parties after this indicating what the final findings were. Thank you both for your participation today, and we'll move on to the next case.
And we'll try to get another case in before a quick break. And that is E230460, Christine Bearer versus United Healthcare. The recommended findings on, I think, just one count is for a finding of no reasonable grounds, and therefore we would hear plaintiff's presentation.
One moment before the parties begin their presentations, this is a matter in which I need to recuse myself, so I will turn camera off and not participate.
Okay, thank you for that, Commissioner Sanders. And then I have here that complaint is represented by Attorney Morris. Are you present, Attorney Morris?
Yes, good morning. I'm here.
There you are. So you have 10 minutes. Would you like to reserve any time?
I won't take the 10, so I don't think I need to formally reserve time.
Okay.
Okay.
When you're ready.
Thank you so much. Good morning, everyone. I represent Christine Bear, who was the best practice director at United Healthcare since 2006. She was terminated in February of 2023. Throughout her tenure at United Healthcare, she was an excellent employee. And from the years of 2017 through 2021, she was either an exceeds or a meets plus rating in her performance at the company. I'm here today because with great and due respect to the investigator, our view is that there is a fundamental misapplication of the standard for determining whether reasonable grounds exist to believe that discrimination has occurred here. And our claim is a Whistleblower Protection Act claim. I know you have the information in front of you and it's been reviewed, so I will not be repetitive or belabor the points, but I want to focus on a couple of things. One is with respect to the investigator's report, there seems to be some question as to whether there was a reasonable or good faith belief or protected activity that my client was reporting what she believed to be illegal activity. And I think it's really important to keep in mind that my client, as a best practice director, was operating in a highly regulated space. She spoke to in her complaint, and she spoke to at the fact finding about concerns with regard to frequent audits by the states, citations that could be issued with regard to some of the changes that she was complaining about that were being made at the company. The whole reason that she made her complaints was because she was concerned about audits and fines by the states. So we would say that there is certainly evidence to indicate that she was complaining about what she believed to be illegal activity. In addition to that, in her complaint, and again, in the information that she filed in this case, my client indicates that at the end of 2022, in December of 2022, she reported to the head of financial protection about the concerns that she had at the company, and she reported to the VP of compliance about concerns that she had about the decisions that were being made, changes that were being implemented, the efforts to freeze out legal and some of the review of policy changes and the impact that it would have on compliance issues. So our view is that there's certainly ample evidence that she was reporting illegal activity. And in fact, the evidence is that an ethics complaint was launched by the VP of compliance about this, my client's complaints. And the evidence further was that the fact finding that the VP of compliance testified that a member of the compliance team spoke to the manager of my client about the complaints that she was making. So there is, our view is that there was ample evidence both of complaining about illegal activity and of the supervisor's knowledge of the illegal activity. With regard to the issues on the W-2 error that were discovered, my client in her complaint alleged that every year there are variances in the W-2 process, and there's talk in the investigator's report about 11,000 W-2s being in error. However, in the complaint, my client alleges that the variance was about $750 out of $54 million of reporting. She then references in her complaint, or alleges in her complaint, her sworn complaint, that the process dictated by the manager who knew about the complaints she was making was chaotic, and it was he was requiring that a file be rebuilt over the course of 2 days. And in fact, the investigator's report indicates that on February 9th, which was a Thursday of 2023, the first error was discovered, and the second error was discovered on February 13th, 2023, was a Monday. So that timeline is consistent with what my client was complaining about in terms of the chaotic process that was required to be performed to sort of audit these W-2 errors, and the inevitability of a second error being discovered. So looking at the standard of at least an even chance of prevailing. And if you consider the fact that there clearly were complaints about illegal activity, so much so that my client went to, again, the head of financial protection and the VP of compliance, and in fact, an ethics complaint was launched, along with the fact that the manager knew that these complaints were made, that then this W-2 issue comes up, a chaotic process ensues, suddenly, oh, a second error is discovered, and there's no progressive discipline, despite 16 years of excellent performance. They move right to termination. We believe that that easily meets the standard that there's a better of even chance of prevailing at trial. I can answer any questions.
Are there any commissioner questions for Attorney Morris? Commissioner David.
Attorney Morris, I am not clear after your presentation of exactly what the illegal activity is. You're saying that she's making comments about procedures and how some things are done, but it seems to me to justify a whistleblower protection, we've got to know what she's blowing the whistle on with some clarity. Are you citing a rule or a statute? Are you citing some further discipline of the company based on that after this all happens? What's the whistle being blown on specifically?
Yeah, sorry to be overly general. So specifically, this new manager was put in place. It began to implement several significant changes. My client was concerned that many of these changes would result in state compliance violations. And she reported her concern that the changes, for example, getting around the payment authority by splitting payments between two different claimants.
Doesn't she have to report them to state regulators to be
No.
then be retaliated for having blown that whistle?
No, she doesn't have to report that to state regulators. She can report that internally and be retaliated against under a whistleblower claim. She does not have to make a state regulator report. She can report, as she did, to the head of financial protection in her company and to the VP of compliance in her company. She can make that report. And she only has to have a reasonable good faith basis for believing that illegal activity is occurring. And that's the report she made. And validating the fact that she was making a complaint about a good faith basis for believing illegal activity was going to occur, an ethics investigation was launched by the VP of compliance.
What's the ethics complaint? Against who?
The ethics investigation was launched as a result of my client complaining about the new manager's practice, making end runs around legal, changing payment policies. There were a number of things that the manager was engaged in that my client believed were illegal.
So then it seems to me that you're saying that they investigated her complaints, and so why is that proof of retaliation?
Well,
sounds like they're listening to her, and
she complained in December. They began to investigate her complaints. This W-2 issue was discovered in January. There was another, an impossible remedy by the manager she had complained about, and she was terminated on February 13th.
Okay, thank you.
Are there any other commissioner questions? Commissioner
Yes,
Douglas.
please. Yes. Attorney Morris, good morning and Happy New Year.
Good morning. Thank you.
Yes. I just want to make sure I understand. Let's just assume that what your client reported meets the standard of the Whistleblower Protection Act, as I believe the report does. Let's just assume arguendo that it does, right? Your argument is that the retaliation is how this W-2 issue was handled, right? It was rushed, and when it comes up, your client says that she's not things aren't staffed correctly, and then there's like a rushed period for her to get this thing right, right? And ultimately she's discharged, right? Without progressive discipline and all this sort of thing. That's
Right.
your argument, yes?
That's correct. And
Okay.
without the progressive discipline, she was treated differently. Variances have occurred. They occur every year, which is what she alleged in her complaint. Others were not terminated. She was.
Okay. And did anybody, since you said that, is there anything in the record about somebody making an error of this magnitude? I understand. I appreciate your comments about the W-2s and what that entailed, but what I'm reading in the report is 11,000 W-2s sent out erroneously the first time, and then another 4,000 the second time, and she didn't tell the company about that second error. So is there anything in the record where somebody else made an error of that magnitude and was treated differently?
Well, I think what one of the factual disputes in the record is that my client alleged in her complaint, which is sworn, that it was a $750 variance. It wasn't of the magnitude that the company made it out to be, which is all part of the pretext. That this W-2 issue was a non-issue.
Right. They said it was like double, something like that, and you're
That's
saying
right.
it's seven.
My client
Yeah,
disputed that. I don't know why my client's sworn testimony was not credited, but she disputed that.
okay. All right. Thank you.
Any other questions from the commissioners? Okay, seeing none. Attorney Morris, you'll have 4 minutes and 2 seconds when we come back to you.
Thank you.
Okay, and then I apologize in advance. I don't want to mispronounce your name. Is it Attorney Piaget?
Correct. Thank you. Good morning.
Do
Good
you have 10
morning.
minutes? Sorry to interrupt. Do you want to reserve any of your time before you begin?
I don't think I'll need to. I'll be brief. Good morning, commissioners. I represent United Health, a respondent. We do not disagree with the investigator's report. We agree that there were no reasonable grounds to conclude that respondent retaliated against Ms. Bearer for sharing concerns that her new manager was changing processes or procedures. We do believe there's a question of whether there was a good faith belief that these violated the law. Despite Ms. Bear's subjective beliefs, her manager and supervisor did work with legal in implementing changes and processes. There was nothing here that was, she would lead her to conclude it was unlawful to implement changes in internal processes. And even if this were to be found to be protected activity, it wasn't the reason for her termination. Although Ms. Bear is, minimizing the concern about the W-2s, it was 11,000 W-2s that were issued, which doubled the amount in each W-2 that was owed, the value. And so that was a concern, and that occurred on January 16th, 2023. She did identify that and reported to her manager. Her manager met with her, they spoke to her. He also investigated and learned that Ms. Bear failed to train her direct report, who was a new employee. She failed to document the processes. She failed to follow the third-party vendors, suggesting that they review each W-2 and look at the errors. The third-party vendor flagged that they had just opened one before issuing the W-2. They would have seen the error. They just failed to review them. They just sent them out. They asked her to correct it. She worked on it. She confirmed to her manager that there was no error. She reviewed it. She'd audited it, issued the second W-2s. 4,000 of them still had errors. And she did not report that to her manager. She received multiple emails about these errors. And the manager learned about it when a customer service side of the company contacted him saying that he's having customers calling saying that W-2s still have errors. So there were concerns, about the impact to the company's reputation, the fact that it's 4,000, that she already knew there was an error, so she should have been more careful in reissuing this. And just for no, I know that Ms. Farah felt a different action should have been taken. Initially, the company was going to put her on a corrective action plan for the initial error. But after the second one occurred and it was found that she was trying to hide it instead of reporting it to her manager, additional concerns came up about her ability in this role to really take accountability for the error and the impact it has on the company's image, on customers' potential tax liability. on the fact that they learned she had not trained her new report, that her direct report said she had questions and Ms. Barrett would tell her to go speak to somebody else instead of answering them. So there's really like a question of how this individual who's been in this role for several years made this big error, did not appropriately train her new employee, and then tried to hide it. And so that's really the sole reason for the termination. Again, they were going to place her on a cap, but the actions around the second error with the W-2 is what resulted in the decision to terminate. And there was no connection to her sharing concerns with the VP of compliance. The manager and supervisor said they were unaware of those concerns. Regardless, it was still not the reason for her termination. It was solely the concerns around the W-2s. And I reiterate, it wasn't 150 variants. It was the value of each W-2 was doubled for each customer who received it. So therefore, we do believe the investigator's decision was accurate. There's really no reasonable grounds to conclude that Ms. Bear's concerns expressed to the VP of compliance was the reason for termination. It was just the conduct surrounding the errors with the W-2s. Thank you.
Okay, thank you. And are there any commissioner questions for Respondents' Council? Commissioner Douglas.
Thank you. Attorney Piaget, good morning and Happy New Year. I just wanted to give you an opportunity to respond to what Attorney Morris said about the lack of progressive discipline, other folks there potentially being treated differently, and so on. Do you have any response? I mean, I appreciate your comments about the nature of the error and the seriousness of it. I'm just wondering if you have a response to that specific point.
My response is like I just said, if there was an idea, the concept was to do initial progressive discipline through a corrective action plan. Regular would give her 3 days to correct her conduct. If it did not work, they would escalate. But it's just she is in a supervisory role. She did oversee several teams. And the decision she made to hide an error of this magnitude, it's 4,000 customers. I mean, sure, the company has several hundreds of thousands, but each customer matters. Receiving a W-2 which shows an increase in tax liability for any individual would be stressful, concerning. They received multiple customer calls expressing concerns. So,
Right.
and she decided just not to report to her manager or supervisor. Like, it was discovered on February 10th, 2023, and the manager learned about it later that day from somebody else altogether. And when he spoke to her, she tried to minimize it or hide or shift blame. She just would not acknowledge and didn't acknowledge that she had actually knew about it before it was reported to him. So that was the reason, along with, just learning as they were investigating that she did not fulfill her duties, which included training her direct reports, creating a document that had the standard operating procedure for the W-2s each year. And, being the supervisor, she's supposed to be, training individuals that are new on this process, but she had done multiple times before.
Okay. All right. Thank you.
Commissioner David.
Good morning, Attorney Piaget. The decision-making persons for the termination, are they the manager and the supervisor?
There were several individuals involved, including the Human Resources Director, advising. It's manager, supervisor, and then one step up, the third, skip level 7, the director.
But not in those three is the vice president. In other words, it seems to be pretty important whether manager and supervisor, the report says, denied knowledge of the complaint to the VP. The alleged complaint of illegal activity is only to the VP. Is that correct?
That's my understanding. It was only to the VP. An ethics complaint was not, there's no record of that, of one being opened on that. My understanding is that the manager and supervisor had no knowledge of the concerns. It wasn't seen as a complaint of illegal activity. It was more expressed by Ms. Barrett as, I disagree with the changes made. I don't think they're okay. And I think the manager's changes should be approved by the supervisor. It wasn't so much that I believe the laws or the regulations are being violated. It's, I believe this new manager shouldn't be changing processes, and his supervisor should be the one to approve them and review them.
Thank you.
Any other commissioner questions? Okay, seeing none, thank you. You will have 6 minutes and 18 seconds when we come back to you. Attorney Morris, you have 4 minutes and 2 seconds if there's anything else you'd like to add.
Yeah, I just have two comments to make. First of all, this characterization that my client was trying to hide something is absolutely inaccurate. There's no evidence in the record to indicate that she did anything to try and hide something. And again, I'll ask you to look at the timeline here. The investigator's report indicates that the first error was discovered on February 9th, a Thursday, and the second error was discovered on February 13th on a Monday. There's nothing to indicate that my client knew about this second error and wasn't somehow reporting it. And to the contrary, again, her sworn complaint indicates that she was in the middle of a very unusual and chaotic process to try and rebuild the files and do 3 to 6 months worth of work in 2 business days. So there's this idea that she was trying to hide something is just absolutely unsupported by the record. And second of all, I know the investigator's report indicates that the managers denied knowledge that my client made a report to the VP of compliance. We dispute that. In the fact finding, the VP of compliance testified that she spoke to a member of her team, and that member of her team spoke to my client's manager about the complaints that she was making. That was the testimony at the fact finding. It's not in the report, which is why we believe in part that there's an error in the application of the standard here. Thank you.
Okay, any commissioner questions for Attorney Morris? Seeing none, Attorney Piaget, you have 6 minutes and 18 seconds.
Just briefly on her trying to hide there. The way it was understood is she received an email on February 9th reporting the error. She just never told her manager until the manager asked her about it on February 10th. And so the concern was not reporting this error again when one had already been made and they had been trying to work together to correct it. And she didn't, and there's really no way the manager could trust that she would have reported it to him if somebody else hadn't told him that the error occurred. Because about a day had gone by and whether or not she was working to correct it isn't the question. It's the fact she didn't report it to her manager when she had no issues reporting the first one the moment she learned about it. Thank you. I have nothing further.
Okay, thank you. Any other commissioner questions for Attorney Piaget? Seeing none, thank you both for your presentations. We'll next hear from the investigator, Bob Bouchain. Bob?
Thank you. I guess, first of all, the determination whether or not this constituted a report of illegal activity, I didn't dwell too much on. Again, I think that it was a close enough call that she satisfied the good faith belief at the time that she made the report. Here, as noted, it was really the question of 10,000 errors acknowledged by complainant that went out in the first batch of W-2s. And then again, the later batch that went out still contained errors. So I think for me, in this case, had there been a single event of a $750 error dealing with tens of thousands of members, certainly it would appear that a lower level of discipline may have been appropriate. But here, where you're looking at that amount, to me, was analogous to the severe and pervasive standard by analogy, that while a single cut would not have been that severe, that given the sheer volume here, respondent was looking at issuing apologies, in essence, to 10,000 separate members. So for me, that was certainly enough for them to take action here. And again, and looking at whether or not complainant hid the fact of the second error was also, to me, largely irrelevant, because regardless of the time pressures, after being called out for making 10,000 separate errors for 4,000 more to go out in the second batch, that clearly, to me, gave respondent more than adequate justification for letting her go in this case, even with the lack of a progressive discipline history.
Okay, thank you, Bob. Are there any commissioner questions for the investigator? Commissioner David.
Bob, it seems to me important to know whether the vice president that receives these complaints, whether that's communicated down to the decision makers about the termination. And we now have in the presentations, Attorney Morris just said that they believe that the vice president spoke to X, I didn't write it down, who then spoke to the manager. Your report says that a manager and supervisor denied knowledge of the complaint. How did they deny knowledge? Focus on that conclusion. Do you agree that it would be important? And the only count here is a retaliation.
Right.
So the decision makers about terminating her have to know about the complaints in order for it to be a retaliation.
There was conflicting testimony on that as to whether or not that the decision makers on the discharge were aware of the prior report she had filed. And I'll even go so far as to say that even if complainant was accurate on that point, that still wouldn't override the fact that we're talking about thousands and thousands of mistakes that went through. And as I said, with the first batch, certainly my math skills could be called into question. I see how that might be enough. But for the second batch to go out, even with the time constraint, just shows a lack of attention to detail that you wouldn't seem to be allowable given the nature of her position, which indicated that these tax documents went out on a yearly basis. So as I say, whether or not a decision maker was aware of the report or not, or even the individual who was singled out, that still wouldn't override the sheer volume of errors that respondent was going to have to answer for due to complainant's negligence.
Okay, I mean, I'm pondering then that maybe it's a question for counsel. If it's partly due to, I mean, she has to show that the issue about the taxes and those errors are not a pretext. If it's partly if her termination is partly based on retaliation for the report and grossly negligent mistakes, does the fact that it's partly based on the retaliation make it discriminatory, Barbara? Do you have a comment on that?
So I'm sorry, I'm not sure I'm following what you're asking. The retaliation has to be a determining factor in the decision to discharge her. If you're
That's
just
the
asking,
that's the answer, determining factor. Yeah.
yeah, and I express no opinion as to whether it was or wasn't.
No, but my question was whether legally, what status does it have to take in terms of the decision? And you're saying it has to be a determining factor, and I think that's significant.
It's a determining factor is the standard. So it doesn't have to be the only reason, but it has to be a but for reason. So it wouldn't have happened if she had not reported.
Thank you.
Any other commissioner questions? Okay, seeing none, we've heard from the parties, we've heard from the investigator. This time we'd be looking for a motion, and there is one proposed finding. Commissioner David.
I'm going to move that we find that there are no reasonable grounds to believe that respondent retaliated in violation of the WPA.
Do we have a second?
Second.
Commissioner O'Brien. Any discussion?
Yeah, I just want to say I don't want the record to continue to have my own mistake when I initially asked about whether or not to be a WPA, it had to be a report to an outside official. I understand that that's not correct. That's not the basis of my decision. my decision is based on the fact that it does not seem, especially in view of the investigators' conclusion that the supervisor and the manager were not aware that that's their testimony in the case, even if there's a conflict about that it was would rise to being a determining factor, and that the errors are egregious and sufficient in terms of the tax situation.
Okay, thank you. Any further discussion? Okay, seeing none, the motion is to find no reasonable grounds. If in agreement, you will vote yes. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Okay,
Colin, we're gonna be in recess for 5 minutes.
okay, sounds good. Before we go, just want to remind the parties that the finding was no reasonable grounds. A letter will be sent to both parties with that finding and explaining any next steps if there are. And we're in 5-minute recess. And Commissioner David, before we get started on the next case, there's something that Barbara wanted to address real quick about the consent agenda. So once we get everybody back, I'll let her speak to you all.
Certainly. Let's see if Commissioner
You'll
Sanders.
let me speak? Ah, Colin, thanks.
Megan, you're with us. Mark, you there?
I am.
Yeah. And where's Tom? Yeah. Okay.
We're short, Julie.
Yeah.
Go ahead, Barb.
Oh, we're missing Commissioner O'Brien.
Julie's not back yet.
Oh, I'm sorry. I'm sorry.
Or if she is, she's hiding on us.
Too many marks on the screen.
I do that a lot too, actually.
So, Julie, we're waiting for you if you can hear me.
Well, I guess there's no reason we can't do this while we wait.
Go ahead. We'll be in session.
Okay, so we had a request to withdraw that was missed earlier. So we are talking about case number E23-0472. It's a case on the consent agenda. And we had a request to withdraw because the parties have settled independently. So while normally we would recommend against allowing a withdrawal at this stage where there's been a settlement, we certainly don't want to get in the way of the parties effectuating that. So I would like to suggest that we make a motion to reopen the consent agenda and then vote on whether or not to permit the withdrawal of E23-0472. That was just, it was an administrative error on our part to not have you do it before.
So we will reopen the consent agenda and entertain a motion to withdraw E23-0472. I will make that motion. I do have a question, Barbara. Is if it's a private settlement, are we concerned about public interest or effect on the public?
Are not concerned about that in this case. The recommendation, I don't think that we would have gotten there anyway.
Okay.
I will say you can't just you need a motion to reopen the consent agenda.
Okay.
Because you already voted to accept it.
I'll move to reopen the consent agenda.
Okay. There's a motion on the floor to reopen the consent agenda. Is there a second?
Second.
There's a second. Is there any discussion? Seeing none. Do we want to wait for Commissioner O'Brien before we do the final vote? Oh,
it looks like she's back. Hi, Julie.
I'm back.
So have you heard what's happening?
No, I'm sorry.
Okay, so quick summary. There's a motion on the floor. I'm going to count my input as discussion just for fun. To reopen the consent agenda, there was a request to withdraw E23-0472 that we inadvertently did not present at the beginning of the hearings. And the commission, I am sorry, I can't speak for anyone but me, am recommending that you permit the withdrawal because there has been a settlement in the matter and we do not want to mess that up for the parties.
Thank you.
Okay, so the motion on the table is to reopen the consent agenda. It's already been seconded. Is there any discussion now that we have everyone back?
Well, so Barbara, that is a case-by-case determination that there's no public interest that would cause us to refuse to let them settle it?
Yeah, we look at each case on a case-by-case basis,
Okay,
yes.
good. Thank you.
Okay, so if you're in agreement with reopening the consent agenda, you would vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
And Commissioner Sanders?
Yes.
Okay. Consent agenda is reopened. Are there any other motions? At this point, we'd be looking for a motion to withdraw, to allow the withdrawal of the Green v. UMA case E23-0472.
So moved.
Oh.
Yep. Go ahead.
Okay. Is there a second? Okay. Any discussion? Okay. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Thank you. Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay.
Great. Nope, not quite yet. So now we need a motion to adopt the amended consent agenda.
So moved.
Thank you.
Second.
Second. Okay, you will vote yes if in agreement. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
And Commissioner Sanders?
Yes.
Are you quite done, Attorney Hirsch?
I mean, for the moment, I reserve the right to interrupt at any point in time.
Absolutely. Absolutely. So we will proceed with the hearing agenda, the third case on the agenda, which was not the third case in the listing on the OneDrive, but it's PA 240015 Deborah King versus Greyhound Lines. The recommendation is for a finding of reasonable grounds to believe that discrimination existed, and therefore we would hear from respondent.
And I believe that's Attorney Silver.
And I'm sorry if I may, Chairman.
Yeah.
David, there was a reasonable grounds finding and a no reasonable grounds finding.
Oh, that's right. Yeah.
The
Okay.
complainant contests the no reasonable grounds, and the respondent contests the reasonable grounds.
I think we'll still take with the more significant in terms of the commission action, to my mind, of finding a reasonable ground. So we'll treat it that way first. But that's true. There is a split recommendation in terms of the various counts.
Thank you.
Okay, Attorney Silver, you have 10 minutes. Do you want to reserve any time?
Sure, I'll reserve 3 minutes.
3 minutes. Okay, begin when you're ready.
Okay, good morning, commissioners. My name's Steve Silver from the law firm of Littler Mendelson. I have the pleasure of representing the respondent, Greyhound Lines, Inc. And as Attorney Aiello informed you, this is a partial objection. So there was a split finding in this investigator's report. And Greyhound has objected to the finding that there were reasonable grounds to believe that Greyhound discriminated against Miss King due to her disability by denying her a reasonable modification. You should reverse this finding for 3 reasons. One's an error of law, the second is an error of fact, and the third is a procedural flaw with how we got here. So in this case, just level setting, we're talking about Greyhound buses. I think most of you probably know what that is, or have maybe ridden one yourself. Here, the Greyhound bus operator or driver started his trip from Boston on March 21st, 2023. His route takes him up to Bangor and then back down to Boston the next day. So the operator testified at the Issues and Resolutions Conference. He knew he had a passenger in a wheelchair that would be waiting to be picked up in Lewiston. Before leaving Boston, the operator tested the wheelchair lift on the bus, and it worked just fine. However, when he got to Lewiston, the wheelchair lift would not work. The operator attempted to get the lift to work. He couldn't do so. This particular operator, he'd driven Greyhound buses for more than 20 years and was well trained in how to operate the wheelchair lift. So he knew this was unusual. So to help try to troubleshoot it, he called the maintenance garage in Boston to try to get the lift to work. Again, unfortunately, the operator could not fix the lift and had to notify Miss King that because the lift was malfunctioning, she couldn't ride on the bus at that time. Miss King responded to the operator that she would take another bus with a different company, which she did, and left the scene. So this is where the error of law was made. The ADA anticipates that machinery that aids in accessibility will not always work perfectly. So isolated problems caused by equipment malfunctions like the one here are not violations of the ADA nor the MHRA. Nearly every court in every circuit has found that an isolated mechanical failure is not a failure to accommodate. We cite a few dozen cases in our written objection on this point, so I'm not going to get into all of those. The investigator strays from that law by finding that even though a single mechanical failure is not a violation of the law, Greyhound should have provided a reasonable modification by providing a bus with a working lift. So in other words, Greyhound should have provided the thing that mechanically failed here. That logically renders the ADA and its transportation guidelines meaningless if the reasonable modification is perfection in mechanical operations. That cannot be. And in fact, it isn't. That's not the law. This also leads to a significant factual error warranting reversal. The investigator's report claims that the driver, quote, did not, for example, attempt to find a replacement bus with a working lift or ascertain whether another bus could come through Lewiston to pick complainant up, end quote. But the operator did just that. The operator testified at the Issues and Resolutions Conference that he asked, and it would have taken at least 4 hours, if not longer, for another bus to get to Lewiston to pick Miss King up. And because Miss King had to make a same-day connection in Boston to continue her trip down south for a concert she was attending, she couldn't wait that long. That's a critical omission from the investigator's report because the reasonable modification, or at least one of them the investigator proposes, is wholly unreasonable to wait at least 4 hours to get another bus. And the modification the investigator claims the operator never explored is one he literally did inquire and testify about. So this key factual omission is representative of the third major reason why reversal is warranted here, which is the procedure of how we got here, whereby the investigator who wrote the report is not the investigator who conducted the Issues and Resolutions Conference. The entire investigation, including the IRC, up through the close of evidence, was done by a different investigator, Investigator Nichols. That means Investigator O'Reilly, and through no fault of her own, had to step in without ever having seen nor heard from the parties and witnesses. And the IRC was not recorded. So because there's no independent witnesses or video evidence, this case comes down to credibility. And the First Circuit is very clear, as well as many other courts, that it's impossible to assess credibility on a paper record. So any such credibility conclusions cannot be adopted by the commission. Right? And as one example, it took multiple requests and the intervention of the executive director for Miss King to even provide her daughter's name, the key eyewitness. Why she tried to hide this alleged witness should have raised credibility concerns. Likewise, Miss King claims that her daughter called Greyhound to report the incident on the day it occurred. But there's no record of any such call. And as a Greyhound representative explained, Greyhound switched to an all-digital phone system in 2020. So if a call were placed, there would be a record of it, but there are none. Greyhound has repeatedly requested that Ms. King provide the phone records showing what number was called and on what date and time. To date, we haven't received that. This is vital information because based on that information, if it actually occurred, there might have been video evidence that would have recorded this alleged incident. But we were never provided proof of that phone call. So again, another credibility red flag. But without actually having been the one to investigate the claims and interview and see the witnesses, there's no way for Investigator O'Reilly to make credibility determinations here. So I implore you all to reverse the investigator and find no reasonable grounds to believe that Greyhound discriminated against complainant by denying her a reasonable modification. The investigator already found that Greyhound did not discriminate, right? Just based on disability. So it stands to reason it can't be reasonable grounds for denying a modification when there was no reasonable modification. I'll reserve the rest of my time for rebuttal and happy to answer any questions that you have.
Okay, any commissioner questions? Commissioner Sanders.
Great. Good morning, Attorney Silver. I just want to clarify something you just told us. One, you indicated that there's no record of this phone call the complainant alleged she made right around the same time as these circumstances were playing out. And you told us that if there was a record of this phone call, that we would therefore have what you described as video evidence of some sort. Can you tell us more about that? I'm not sure how a phone call equates to being able to obtain video evidence.
So there's two different numbers that could have been called, right? Customer service, or there's actually an ADA compliance page. So there's a whole website about it, phone numbers, emails. If a customer were to complain and say, hey, I was denied access to your bus, or if as alleged, as the complaint alleges, your driver was rude to me and nasty and called me names, there would be an investigation. There is an ADA compliance person at Greyhound. That's their sole job. So what they would do is there's video cameras. They shoot outside the bus and inside. Now, some buses have audio, some don't. I don't know the answer as to whether this would have had audio, but you would have seen, what actually happened. But again, that gets deleted in normal course. So it wasn't for some time before Greyhound learned of the claim.
Okay, thank you. Also, too, the complainant alleges that immediately upon the driver pulling up to the station, he observed that the complainant was had a physical disability, right? She's in a wheelchair, needs assistance. And the first thing he says to her was, quote, "We're not set up for handicap today." Doesn't that suggest to you that the driver knew, right, had actual knowledge at that point that the lift was not working?
Well, the driver testified at the IRC. He never said that. And in fact, that he gets a manifest beforehand, and he knew that there was someone waiting for a wheelchair. And he said pretty frequently there's riders with wheelchairs. It's not really a big deal. And as part of the pre-ride check, they checked the lift and it was working. So to him, I mean, that's part of the issue here is the driver didn't think there was a major issue, right? He knew there was a wheelchair passenger. He was ready. The lift wouldn't work. He called to troubleshoot. He couldn't get it to work. And according to him, Ms. King said, we'll find another way to Boston. And he went about his trip.
Okay. Let's stay there for a minute on this phone call that the driver allegedly made to obtain help. As I understand it, though, and perhaps you can correct the record, the driver didn't follow the applicable policy, right? So the driver, it appears, was supposed to call a sort of a fleet operations center to figure out, right, how do we resolve this issue? What do we need? Are there ways to accommodate by obtaining another bus? Are there other, strategies to be able to implement here to get everybody, right, on their way to Boston? Instead, the driver calls a mechanic in Boston to troubleshoot. Isn't that a policy violation? And if it is a policy violation, what's your client's explanation for that? And doesn't that fact speak to, right, a failure to accommodate?
No, because what the driver explained is, yes, you're supposed to call that fleet desk, it's called, but that fleet desk will just route you back to the Boston garage. So he decided it'd be quicker to call the Boston garage directly because in his decades of experience, they're the mechanics who work on that specific bus. and they know that bus. So he thought it would be quickest to call someone who knew the specific bus he had, and did ask about another bus, but they got to send it from Boston. And I think the investigator, to be fair, was a little confused, thinking this is some big Greyhound station, right, where there's a whole fleet of buses. It's not. Yeah. It's a city bus terminal, so there's not even a station. They just pick up from the curb. So they'd have to send a bus from Boston, right, which means getting a driver to get to there, to get a bus to bring it up. So you're looking at, again, minimum 4 hours.
Is that the only remedy, though? I guess I'm trying to laser in on what's the purpose of calling that fleet operations center if the only remedy, right, that ops center could implement was a phone call to the mechanic? If, in other words, right, let's play out the counterfactual here for a minute. Had the driver called that operations center, what other remedies could they have suggested to deal with this situation effectively?
Yeah, well, so the fleet desk would be useful if you were in a time zone situation, right? So after hours where nobody's picking up at the Boston garage, right? Okay. There's nothing else that they could have done. It would have been the same advice to try to fix the lift. Now, complainant believes that either sending another bus or paying for a taxi for her to get down to Boston would have been reasonable. We certainly don't believe that is, given the volume of passengers that ride on a Greyhound bus every day. If they were paying several hundred or maybe even $1,000 for a rider to go that far.
Okay. I also see too, right, you're questioning the credibility of the complainants here as part of the defense of your claim. I noticed, though, in the complainant's submission, Attorney Aiello procured affidavits, right, sworn testimony from her client as well as her client's daughter. Are you suggesting to us that the client and the client's daughter, Miss Aiello's or Attorney Aiello's clients, are lying to the commission?
Well, I think you have to take into account that the daughter is not disinterested here. And it certainly raised red flags that this eyewitness, right, just referred to as the critical eyewitness throughout this, was kept hidden until suddenly the executive director stepped in and said, you got to tell them who the witness is. And it's her daughter. The daughter is the one who allegedly made the phone call. So that's not Miss King, that's the daughter. Again, no proof of the phone call being made. Do I think it was upsetting for Miss King? Absolutely. But I'm sure there was probably some level of panic that she would miss her connection and not get to the concert. No one's denying that. And certainly Greyhound wants to serve its passengers. That's why its buses are equipped to do so, and they do so for thousands of riders every day. But when you're talking about whether there was discrimination or a failure to provide a reasonable modification, this is an unfortunate situation where there wasn't anything else to do. And Miss King, although she disputes it, according to the driver, told the driver, I'll take another bus, and did.
Okay. To date, have any of the parties here been reimbursed for the cost of their fare?
I don't know the answer to that.
Yeah, Commissioner Sanders, information is not on the record, but I can answer it, what information we do have.
Okay. All right. Great. Thank you for that. Just one last comment as well. You noted in your opening presentation that the complainant here seems to be, or is in fact, alleging that or arguing that the relevant disability provisions of the ADA and the MHRA require perfection, right? That the lift must work. I don't read that to be complainant's argument here, and so I'll be looking when Attorney Aiello has her time to present to speak to that particular point. So thank you. That's all I have.
Commissioner O'Brien, I saw your hand first.
Thank you. And thank you, Commissioner Sanders, for asking a lot of my questions and commenting. Good morning. I want to go back to the refund question. Allegedly, the driver said, if you're nice, you can talk to them about a refund. Could you explain the refund policy? I mean, is it a policy that no refunds in this situation would be given? I mean, this To me, this appears if a refund were to be given, this would be the type of thing that it would be given for. Can you explain the policy? Thank
Hey,
you.
you're exactly right. If the phone call was made
Oh.
as it was alleged, then they'd absolutely give a refund. She didn't get to ride. I mean, that's the problem here. There's multiple layers of the alleged phone call that would have triggered a refund, triggered an investigation by the ADA compliance officer, and triggered a video poll and an interview of the driver at the time. The driver retired by the time this charge was even filed. So again, that's the problem. Do you have this alleged phone call that would have triggered all of these things, none of which occurred, and there'd be a digital record of it? It's not as if someone called and you're requiring someone to log it, manually log it in. That's not how the system works. And that's the key problem when you're talking about credibility here.
And Commissioner Douglas, did you still have a question?
I do. Yes. Attorney Silver, good morning and Happy New Year. I just wanted to revisit the wheelchair lift argument that I heard you make in your initial presentation. You cited a bunch of cases that say that an isolated failure of the lift is not discrimination under the ADA. And I checked out some of those cases, but that's not really the analysis here, right? The analysis that's not necessarily the denial of a modification, the failure of the lift. So then, the question, as far as I understand it, is, did the driver do enough other than once the lift failed, did they do enough? And I just want to make sure, because you said something else about if there's no, I don't know. I just want to make sure I'm understanding the import of this argument that you're making and make sure I'm not missing anything. Like what in your mind is the relevance of this whole, isolated lift not working issue, the case law you've cited, in light of the fact that the analysis here seems to be what else did the driver do after the lift failed? What am I missing here?
Well, because the investigator's report says, well, the reasonable modification would have been providing a bus with a with a working lift. So, of course, that would be the initial goal. And then the second step would be, well, that leads to you got to get another bus. The other bus would take 4 hours at least. So that's not reasonable. So how can you say there was no reasonable modification offered when the modification proposed is just getting another bus? That's all that's in the report. The driver did inquire about it, but that's not even in the report, right? That's the other problem. So it's all tied into one, which is you say the modification is getting another bus and that the driver didn't inquire about it, but he did. So, and it wasn't reasonable for Miss King. So I don't know how we got to this position here with this split finding. And I'm sure Attorney Aiello is going to argue the flip side of that coin, right? How do you get to a split decision with finding reasonable grounds on one and not on the other?
Yeah, I'm sure she will. Okay. So it sounds like we're on the same page then. So thank you.
Commissioner David.
Good morning, Attorney Silver. Commissioner Sanders first asked you about the point that I was focusing on at the beginning, and that's this alleged comment that the first thing the driver says to her, looking out the door and seeing a woman in a wheelchair, we're not set up for that. And that's not consistent with finding out that the lift doesn't work. I didn't see, you say that he denies that. I guess the first question is, in the face of testimony by the complainant and the daughter, who's an adult and gives a sworn statement, even though she's the daughter, she's testifying that comment was made. Why isn't that a credibility issue? You talk about credibility. Why doesn't that meet the standard of as likely as not to convince a jury at trial?
Well, I think you've highlighted the problem here. We have one party who says one thing, the other says another, right? There's no independent witnesses. And so it's a credibility determination by the investigator, but the investigator didn't conduct the IRC. So how do you reach that conclusion? And maybe there's nothing to do. Maybe it's just a procedural or just a, something that happens because of personnel related decisions, right? And it cuts both ways. You're exactly right. But it highlights the fundamental problem that if you're finding reasonable grounds, right, and what that means for the respondent, you've got to meet that standard. And I don't know how the investigator can do that when they didn't interview the witnesses, and we requested recordings of it, and we're told there were none, so couldn't even watch it.
If that statement is made, that the first thing he says is we're not set up for it, that suggests to me that he's blowing it off and saying I'm not going to deal with it. And I can think of 6 other things you say that she's demanding that they get another bus. I don't think that's true. I think there's a lot of other ways to resolve the issue. But okay, thank you.
Any other commissioner questions?
Just one last question for Attorney Silver. I see, certainly in the affidavits that were presented, as well as in Attorney Aiello's disagreement or statement of disagreement, the sort of the conduct, right, and the attitude. I suppose I would characterize it as that the driver displayed in the context of his interaction with the complainant's daughter, and her grandson. Does the driver dispute the characterization here, specifically that he was hostile, dismissive, sort of, not concerned about the complainant's needs? Is all of that sort of a matter in dispute and up for a credibility determination as well in your mind?
I mean, the driver, and that's the problem. The driver was a great witness, totally disinterested. He retired, fully retired by the time this charge was filed. The IRC, he's got nothing to gain. He's not a current employee. He has serviced customers in wheelchairs for 20 years. He actually said he's won an award from Greyhound for going above and beyond for helping customers in wheelchairs. He recognized Miss King as someone who's ridden in the past. He picks up passengers all the time. He just denies it. And again, he testified, yep, when I start the trip, I said, someone for a wheelchair, that just requires him to get up. They shift the seat and put the lift down and bring someone in. So he never said that. And he also disputes the post-incident characterization of, the crying and being upset. He said they were calm, polite, said they'll take another bus. So just totally diametrically opposed stories as to what happened.
Okay, thank you.
Okay. Last chance. Any other Commissioner David?
I did want to make to direct your attention to the one other point. The fact that the two recommendations are different. The terms and conditions, I can agree. I think I do agree that and I'm going to be interested to hear Attorney Aiello's reasons to the contrary. But that seems to suggest that the policy was not in place to accommodate wheelchair passengers, and clearly it was, and they have a procedure to put it on the ticket and all of that kind of thing. So I think that's a different situation from his reaction, as Commissioner Sanders has focused on, in terms of how he dealt with this situation. That's all.
Okay. Moving on. Attorney Aiello. Oh, I'm sorry, Attorney Silver. Well, you'll have 3 minutes and 20 seconds when we come back to you. Attorney Aiello, you have 10 minutes. Would you like to reserve any of that time?
I'll reserve 2 minutes, please.
Okay, 2 minutes. Begin when you're ready.
Thank you. Good morning from Hollowell, Chairman David and Commissioners. My name is Kristen Aiello, and I represent the complainant, Deborah King. It is really hard, as I'm sure many of you can relate to hear fiction from your opponent. It's hard to know where to even begin. First of all, the bus driver did not recognize my client. He mixed her up with someone else who had used a wheelchair at some point later. The Greyhound provided no records, phone records of the driver checking other bus operators. My client and her daughter were watching him the entire time. There was no affidavit, there was no sworn testimony from any witness from Greyhound. My client was upset at the fact that the driver perjured himself, as well as the employee from Greyhound who testified at the Human Rights Commission that a call was made. And the fact that Attorney Silver is focused on my client's daughter and making wild accusations that she was somehow hidden, that is absolutely ridiculous. I guess that's what you do when you want to deflect attention from your case. In this case, I will begin with a simple proposition. The investigator got this exactly right on the reasonable modification, and partly wrong as a matter of law on the terms and conditions. I want to, I provided sworn affidavits from my client and her daughter, who were both there, and I will underscore that they were watching the driver the entire time because they were traveling. They were worried about my client getting on the bus to catch the bus in Boston, and it was a stressful situation, so they didn't take their eyes off the driver the entire time. My client reserved and paid for the ticket, and there is no question, my client testified and as well and stated in her affidavit that as soon as the driver saw her, he said, "We're not set up for handicap today." After it took the daughter boarding and showing the driver the ticket to say to show that that she had reserved her seat, and the driver commented, "No one told me," and very negatively said he'd have to arrange seating. The bus driver slammed the equipment, whipped the slider open, made a scene as my client described. He made no calls for assistance, offered no alternative accommodations, gave no ADA contact information, and just told Ms. King, "Nope, not going today. And if you talk nice, maybe you'll get a refund." This is a flat refusal. And there was no attempt at accommodating my client. The investigator was right on reasonable modification. The investigator correctly found that Greyhound violated Section 4592(1)B. Under the DOT regulations cited by Greyhound, and I'll note that there's virtually very little, if any, citations to the Maine Human Rights Act. Section 4592(1). Instead, we have a string sites that are self-serving from Greyhound that don't apply the Maine Human Rights Act to this case. But even under the DOT regulations cited by Greyhound, which they have not highlighted, when an accessible feature is out of order, the entity shall take reasonable steps to accommodate individuals with disabilities who would otherwise use the feature. In this case, the evidence is clear that once the lift did not operate, Greyhound failed to come up with or take any kind of reasonable steps to ensure access. Attorney Silver plays a little fast and loose in his presentation. There was no statement about what they should have done. There were examples given about working with her to talk to her about reasonable accommodation. And interestingly, there's no requirement that an individual riding Greyhound call Greyhound to report something. But of course, Big Law and Attorney Silver is putting the burden on my client to say, and focusing attention on my daughter making the phone call, which she did to Greyhound. And really, instead of focused on looking at the accommodation that was not provided and the service that was not provided, Greyhound is focused on whether or not my client's daughter made a call, which she submitted an affidavit on, and under the even chance of prevailing standard, clearly she's met her burden of providing that evidence that she's asserted. So this case is so clear that Greyhound failed to provide reasonable modification, did not make even the efforts to provide any kind of, even a phone call, even sharing information about what she could do. Instead, my client was left on the curb in her wheelchair. Now, the investigator erred as treating this only as a reasonable modification case. Greyhound here, the evidence shows that Greyhound imposed inferior terms and conditions, saying to someone who paid for a ticket and did not get service, did not get a refund, saying to them, call Greyhound and maybe if you talk nice, you'll get a refund. That doesn't go into the category of no reasonable modification. That is a failure to inferior terms and conditions and failure to provide equal terms, terms or conditions of service. And I cited Section 92 or the Human Rights Act, Section 4592(1), a number of times in my submission because that's what we should be looking at. Look at the language in that. It says it's a very clear, very sweeping language that's also in the Human Rights Commission rules. You can't indirectly or directly withhold or deny on account of disability any of the accommodations, advantages, or privileges of a public conveyance, or for such reason in any manner discriminate in the price, terms, and conditions. There's no reason that this case should be limited to failure to provide reasonable modification, which clearly my client has shown. But also the failure to provide full and equal enjoyment is also actionable. I would also add that under the Maine Human Rights Commission rules, subchapter 5, applying to public conveyances, meaning buses, disability-based conduct that interferes with access to a public accommodations, goods, or services, or creates an intimidating, hostile, or offensive environment violates the Maine Human Rights Act. Having the situation, having the driver eyeball my client and say, we're not equipped for handicap today, having the driver say, nope, not going today, having the driver make a few cursory attempts to make the lift work and then slamming it and driving off, giving my client zero information and zero effort to be accommodated, all is a violation of the Maine Human Rights Act, including creating an offensive or hostile environment. This was not a neutral mechanical interaction. It was a hostile treatment tied directly to disability imposed publicly at the moment access was denied.
Attorney Aiello, that's 8 minutes. Sorry to interrupt you. That's 8 minutes. Did you want to continue or use your last two?
I'll just use maybe one or whatever's, maybe one additional minute just to say Greyhound wants to talk about mechanical failures, not the Maine Human Rights Act. They found a DOT regulation, which they've highlighted, which is fine. But they have failed to highlight the section that says the DOT regulation really asks what happens after a failure, which is exactly what the investigator did. We all understand that equipment sometimes failures. Here, the evidence is clear. Greyhound failed to take reasonable steps to provide access to Ms. King. We ask that the commission find reasonable grounds on both the failure to modify and also the denial of full and equal enjoyment and discrimination in terms and conditions. I'm happy to answer questions and reserve the rest of my time.
Okay, Commissioner questions for Complainants Counsel. All right, seeing none, you will have 1 minute and 15 seconds when we return to you.
Thank you so much. Thanks for your attention.
With that said, Attorney Silver, you have 3 minutes and 20 seconds if you wish to use it.
Thank you. First time I've been attacked personally in my firm, so it's unfortunate it's come to that. The operator, the bus operator, and the ADA compliance specialist from Greyhound testified at the Issues and Resolutions Conference. The reason, again, why the phone call is so important is because if it were made, and if complainant's daughter could produce proof that it was made, which she can't because we know it wasn't, there would have been an investigation, and that investigation has to be completed within 30 days. It never occurred here. The driver is made out to be some monster. If you were able to view him and listen to him, it is the exact opposite. It's someone who, again, drove for nearly 30 years, loved his job, retired, and was very matter of fact as to what happened here. It's unfortunate that Miss King couldn't ride. But in terms of what's a reasonable modification, Sending another bus wasn't one. And there was no other way to get her there other than, I suppose, you could find that the company needs to provide and pay for a taxi to take passengers wherever they're going. That would effectively, shut down the ability to provide this service, which a lot of people ride every day, hundreds of thousands of Americans. Doesn't seem reasonable to me. And again, it is a credibility determination. The investigator, unfortunately, wasn't able to attend and view the IRC. And in terms of the law, there's certainly an abundance of cases that say that, the contours of the MHRC or MHRA, are the same as the ADA. The provision that Attorney Aiello cites talks about equal access. There's absolutely equal access here. It was a mechanical problem. Nobody denied her outright her service. There are ways to try to fix it. It didn't work. This is extremely rare, and it happened, but that doesn't mean that discrimination occurred.
Okay, thank you. Any commissioner questions for Attorney Silver? Okay, seeing none. Attorney Aiello, you have 1 minute and 15 seconds. If you'd like to use it.
Thank you. Discrimination is complete on the denial. Discrimination does not depend on whether or not an individual somehow tried to figure out a number to call on her phone and make the report. Greyhound is trying to say that it is my client's fault for what they did in terms of not accommodating her and treating her differently in terms and conditions. Greyhound is not taking responsibility for what happened here, nor have they ever taken responsibility what has happened here. The standard here is even grounds. The complainant asks and believes strongly that she has met her burden to show that there is an even chance that she would prevail on both Greyhound's failure to provide reasonable modification and Greyhound's failure to provide terms and conditions and equal enjoyment to my client. Thank you for your attention. Yes.
Commissioner David.
Attorney Aiello, I still don't understand the argument that that they violated terms and conditions, that they've discriminated based on disability in the terms and conditions of the service that they apply. I hear the argument clearly about and the finding about reasonable grounds about not providing an accommodation for this specific situation, but it seems to me, and maybe I'll be asking our counsel for a further discussion about what terms and conditions means. Isn't that policy? Isn't that Greyhound saying we don't deal with people with wheelchairs or something like that?
Well, I would go back to the language of the Maine Human Rights Act, which talks about discrimination for any such reason in any manner to discriminate against someone in the price, terms, and conditions upon which access to such accommodation. And so going back to the very sweeping language of the Act, I think that it doesn't limit it to policy. If it limited it to policy and procedure, it would say it in the Maine Human Rights Act. The Maine Human Rights Act is a remedial statute that is sweeping in nature on this point. So to arbitrarily limit it and try to parse out what that means in terms of the plain language, price, terms, or conditions upon which access may depend. So
and you're saying the condition that they violated was not providing the service because of the broken lift.
I'm saying that there was that she was discriminated against on the price. They never refunded her money. They took her money, told her that she can, if she talks nice, she'll get a refund. That's discrimination in terms and conditions. That's a separate claim. And also, if you look at your own rules, you'll see that harassment on the basis of physical and mental disability says plainly is a violation of 4592 of the Maine Human Rights Act. And that definition is also quite broad, has the purpose or effect of unreasonably interfering with an individual's access to any of the accommodations, facilities, advantages, or privileges of a public accommodation. And creating an offensive experience. My client uses a wheelchair. She needs assistance. She was in a position where she was told outright she couldn't. She wasn't riding today. She wasn't riding today, and maybe she could get a refund. If that's not a denial, I don't know what is. Thank you.
Yep.
Yes.
Yes.
Yes, thank you.
Guess good morning and Happy New Year, Attorney Aiello.
Same to you.
I know that this is going to come up again, so I just want to be clear, follow up on Commissioner David's questions. In terms of the terms and conditions argument that you're making, right? And I rest assured, I have the statute in front of me.
Yes.
The argument, as I understand it, is the refund, right? She did not get a refund. She couldn't ride because the lift was broken. And then, I mean, she didn't get a refund. The driver says, if you call and ask nicely, maybe you'll get a refund, right?
Yeah.
What else? I just want to make sure we get it all. What else? What other facts are you relying on? Specific facts in this case to support your terms and conditions argument.
Yes, I think the facial disability exclusion, we're not set up for handicap today, is a violation of terms and conditions, as well as explicit discrimination. The hostile and demeaning treatment, the public humiliation, the unequal treatment, where passengers without disabilities boarded and traveled without interruption, and she wasn't. She was subjected to stranding and segregation, and she had economic harm because she paid for a ticket that she never was able to use despite her efforts, and she's not someone who can really who could even withstand that loss of money for her ticket. So all of those things, I'm not saying they're limited to that, but I think that I'm looking at the statute and saying this is a very broad and sweeping statute. And this goes beyond simply a failure to accommodate, which I think is also met.
Okay, thank you.
Okay, any other questions from the commissioners?
Just one last clarifying question.
Yes.
Attorney Aiello,
Yes.
really, and if correct me if I'm wrong, but the sort of the factual posture of this case sort of fully comes down to credibility assessment. Is that correct?
Certainly, I think that's certainly one of the issues. I mean, I think that the conclusion was wrong as a matter of law and as a matter of fact on the terms and conditions.
Okay.
But I think credibility is certainly an issue. And yeah.
Okay, thank you.
Thank you.
Okay. Seeing no more questions from the commissioners, we will hear from Jane O'Reilly, who wrote the report for this case. Jane?
Morning, commissioners. Thank you, Attorney Hurd. Yes, as was pointed out by Attorney Silver, I was not the investigator on this case initially. However, as is our policy and has been the case on many reports that have been issued by the commission, I fully reviewed the record. I reviewed and finalized the report. I'm confident in presenting the case today. Generally speaking, if the commission doesn't feel confident about a report, it's not issued. Not just generally speaking, true for every case that's presented. So to the extent that my familiarity with the record is at issue, I'm happy to answer any questions regarding that. With regard to the terms and conditions, because we just sort of ended on that point, I'll just refer you to footnote 1 in the report, which kind of touches on the sort of facts that were considered separately as the terms and conditions claim argued by complainant's attorney. I sort of agree with, I think some of the questions have been leading this way with the commissioners, that most of the facts go to the claim of denial of reasonable modification and don't rise to the level of a separate claim of terms and conditions. She was otherwise treated similarly, as all customers were similarly treated in the situation. None of the examples or hypotheticals provided by the complainant's counsel were persuasive in terms of a separate terms and conditions claim. So the report focused on the denial of reasonable modification. I will point out just a couple of things, one of which is that it's been suggested by Respondents Council that the finding in this case is that Greyhound should have done a specific modification, which was provide a bus with a working lift. That is not what my report finds. My report does an analysis on the final stage of a reasonable modification claim, which is that a respondent has to provide the modification unless it is an undue administrative or financial burden. In this case, while they couldn't provide the lift, a functioning lift on the bus because it did not work, there was no additional conclusive undisputed fact about what occurred afterwards to show that respondent made efforts to determine if there was another modification necessary. If they had provided that evidence and shown that that evidence was that they tried other things and there was nothing else available, this case would have come out differently. But in the case as it was presented, as you can see from the way the attorneys have presented the case this morning, there are a lot of disputed facts. There were not a lot of people involved in this situation. And so as often happens with our commission investigations, when that happens, we come down on a finding of reasonable grounds because it seems just as likely as not as complainant's version is true. Certainly no one's disputing the lift didn't work. And so again, my analysis focused on what happened after that. And there is significant dispute about how that was handled, how frustrated the driver seemed, whether or not she was provided with any kind of contact information. I will say that the record does not show that there is in fact a customer service number. Respondent provided in its submissions and at the IRC that there's a customer service email or a customer service sort of online portal, which they say means that complainant could not have called customer service. That was they said that complainant's credibility should be called into question because she couldn't have called customer service, that she probably called a reservation line, which would not have been able to assist her. So again, there's continued even today more factual dispute about what information there was, what information should have been given. So based on that, that's where my finding came out. Certainly, some of the arguments that have been presented today that, getting another bus would have been ridiculous, but my reading of the record and my reading of the facts that are in this record, in this report, are that while the driver said it would have taken 4 hours to get a new bus and that's unreasonable, that didn't come from his inquisition with a call to the fleet desk or his attempt to determine that that was not possible. And that's the evidence that we would look for in this case, that respondent did the investigation needed to do to determine that there was no other modification that would have gotten her on the bus or gotten her another trip or otherwise assisted her. So with that said, I'm happy to answer any questions.
Yes, good morning.
Good morning.
Happy New Year.
Happy New Year.
Yes, first of all, let me express my confidence and support for your work on this case in general and the report that you turned out, notwithstanding the fact that you were not the original investigator. I have every confidence that you did what was needed to advance this case, and I appreciate that. With respect to footnote 1 and the complainant's terms and conditions argument, I don't see an analysis of the argument I heard this morning, which is that it's the price, the lack of the refund is something to do with that. What I'm wondering, was that presented before, and or do you have a position on that, or did you develop a position on that during the course of your work on this case?
Yes. So every complainant's attorney has not presented any new arguments this morning. All the arguments that Attorney Aiello presented were presented during the case. So again, with the issue of the issue of bad customer service, which this sort of all comes down to, right? You're dealing with a driver who's rude, a driver who doesn't seem like they want to help you, a driver who doesn't provide you with the tools you need to get a refund. In order for that to rise to a separate terms and conditions claim, it has to sort of reach the level of interfering with your ability to access those services, and it has to be based on disability. That's what I found the record did not support. Anything that indicated disability was related to the modification, not to sort of general customer service, and everything else didn't rise to the level of interfering with her ability to access the service of a bus ride. So that's where that analysis came down. But yes, everything that Attorney Aiello presented this morning was part of the arguments in the case.
That's perfect, Jane. Thank you.
Commissioner Sanders, did you still have a question?
I do. Thank you, Investigator O'Reilly. Really appreciate your work here. I want to give you an opportunity to respond to a question I or something that I think I specifically heard from Attorney Silver during his presentation, that very specifically you're not able to assess the complainant and then the respondent's credibility here because you were not the investigator who conducted the conference. So I want to give you a chance to respond specifically to that and talk a little bit about how did you assess the party's credibility here?
Sure. Well, as personally, I often find it difficult to, even if I do have just a recording or a visual, or I'm talking to people, my credibility assessments are often based on information. So consistency, consistency with how people present their stories, plausibility in the way that they tell their stories, whether or not, certainly, as Attorney Silver pointed out, family members are not the most reliable corroborating witnesses because they have motivations to, corroborate their family members and things like that. That was taken into account. All of those things are taken into account, and there are detailed, while the IRC is not recorded, there are notes. We are required to keep notes. All of our reports are reviewed by Commission Counsel, who needs to have an accurate record of our meetings in order to assess our reports. And so I was able to review all of the written information that was provided, in written form. I was able to review the information provided by the parties, as well as the affidavits provided by complainant's counsel and any other information provided by respondent, in order to determine what, in this case, was the quote unquote truth, or what I thought was the most plausible situation that occurred. And I would disagree that this case is super clear cut. I think the facts are probably clear as mud. I mean, again, 3 people reciting something that happened a while ago. In this case, I really found reasonable grounds on the basis that I couldn't really tell what had happened, that both people, people are motivated to lie for a bunch of different reasons, and are equally not motivated to lie for a bunch of different reasons. And so in this case, everyone was pretty consistent. Everyone was pretty reliable in terms of the plausibility of what they were saying happened. They just differed significantly. And in that case, the one thing that was consistent was that both, while the driver and complainant and her daughter reported different temperament with regard to the situation and how he provided information, everyone agreed that they were not given any contact information. Driver says he didn't give it because they said they were going to provide another bus. Complainant says he didn't give it because he was rude and didn't want to. But either way, complainant was not given any additional information as to what efforts respondent was making. And complainant was not given any additional contact information for herself to reach out to find out what other modifications could be made. And so ultimately, those facts are the most important for me to determine whether or not there was a denial of modification. So
okay, great, thank you. I want to follow up on footnote 1 as well. So thank you for directing our attention to it. At the very sort of second to last sentence, you write, quote, "To the extent complainant alleged that respondent created a hostile public accommodation environment, that claim also fails. Respondent's actions were neither severe nor pervasive, nor based on complainant's disability," end quote. I'm curious about that. If we accept the complainant's version of events, so with respect to the driver's, conduct, temperament, attitude, talk to me about how you drew the conclusion that sort of behavior throughout the interaction does not satisfy a severe standard.
So severe, pervasive, severe incidents, in order to raise, across the board in terms of hostile environments, it's a pretty high standard for one incident to rise to the level of severe. For the most part, we're talking about, slurs, physical assaults, threats, these types of things. One incident would rise to the level of severe. Pervasive conduct can be lesser and continuing to sort of rise to that level. So in this instance, those are the standards I was working with, and my assessment of while the comments were rude and otherwise unpleasant, did not rise to the level of severe based on that one interaction.
Okay. When I first asked Attorney Silver a variety of questions, the first question I asked, and you let me know that although the question of the refund is not in the record, that you would respond to it during your portion of our time here. I want to give you the opportunity to do that.
Sure. So the reason I jumped in is because up until this point, I don't know what happened after the record was closed. At the time the record was closed, complainant had not received a refund. That information was not, they tried, they didn't get one. And as far as the record shows, she was still out that money as of the time the record closed. I don't know if anything's happened after that.
Okay, thank you. And then finally, there is a matter of, it appears that there's another witness here, a gentleman who allegedly approached the complainant and her daughter immediately after the set of circumstances that's described in the report. And, not knowing, of course, who this person is, was there any effort made in the underlying investigation to identify and locate that witness?
So he was identified. He's unfortunately an unhoused individual who they don't have any information on and was transient. So there was complainant did identify that person. They said there was a person and they couldn't produce who it was because they didn't have any information about him except that he appeared to be unhoused.
Okay, thank you.
No problem.
Any other commissioner questions? All right, seeing none, thank you, Jane. We've heard from the parties and the investigator, so at this time, we would be looking for a motion. There are two proposed findings, which you can either take together or separately. Do we have a motion?
Yeah, I'll make a motion to, I guess I'm going to ask my fellow commissioners if anybody wants to take them separately. I'm comfortable taking them together, and the motion would be to adopt them, that there are reasonable grounds to believe there was discrimination based on disability and modification, and that there are no reasonable grounds to believe that there was discrimination in terms and conditions.
Is there a second?
I'll second that.
Okay. Any discussion? Commissioner O'Brien.
Thank you. Just briefly, credibility and lack thereof has been thrown out here through this entire thing. The parties, the council, the investigator, and that is exactly why I will be voting the way I'm voting. So leave it at that.
With respect to the second finding, the no reasonable grounds recommendation, I'm really focused in on, again, if we apply the reason, as likely or not to prevail at trial standard, my sense is that based upon the sworn statements that we have here from the complainant and a witness to the circumstances, that it at least meets that particular standard, and that we should vote to find in the alternative, meaning that we should find that there is a reasonable grounds, conclusion has been met. The other thing I'm worried about too, it's troubling to me, this case, of course, like any case, by the time it reaches hearing, has been, pending for some, period of time. If it's true, and it sounds like, and I heard from the investigator O'Reilly here, that as of the close of evidence, there was still no indication that Greyhound had refunded the complainant their money. That's troubling to me. That alone could be grounds for a reasonable grounds conclusion on the terms and conditions claim. And so I'm worried about that. Greyhound, certainly had ample opportunity to investigate at the very least, even if there was a credibility determination that Greyhound made, right, that did not go in the complainant's favor, as a demonstration of customer service and understanding that this matter was in dispute, it's puzzling to me why, Greyhound wouldn't have just done that as a matter of good faith. So I'm still struggling with the no reasonable grounds recommendation as to the terms and conditions of service claim.
So I had been under the impression, I appreciate that, Commissioner Sanders, first of all. I'd been under the impression that in order for that claim to be successful, the whatever the activity was needed to rise to the level where it interfered with the complainant's ability to access that accommodation, right? That public service. I think Jane just explained something like that to us. And so I think that's where we part ways, I think. If I'm correct on that, if I'm correctly reciting that standard.
I wonder too, and maybe either Jane, I don't know if it's procedurally appropriate to ask for either Jane to respond or Barbara to respond. But could you, the point that Commissioner Douglas just made, Barbara, can you respond to that?
I can. And I want to focus in first and I'm looking at footnote 1, which no one will be surprised to know Jane did not write. And I think a key piece here is that there is not evidence in the record that this happened because of disability, the attitude, the no refund. We don't know that people who were not disabled would get a refund in that situation. We don't know if the attitude was because complainant was disabled, or because the driver was annoyed that the lift wouldn't work, or because it was cold out, or whatever it is. But there hasn't been established a link that any differing conditions, and I realize there was the statement, we're not set up for disability today, but that by itself did not affect, if we're talking about the hostile environment, it didn't create an abusive environment. And if we're talking terms and conditions, there was what affected complainant's ability to ride the bus was the lack of an accommodation, not any different terms and conditions that were otherwise generally applicable.
I hear that, Barbara, and I think that's correct. I agree that second grounds is more troubling, Megan, but I still believe that it's not connected, and that we should vote that there's no reasonable grounds on terms and conditions. The violations here are that there are, a number of things that could have been done that were not done to accommodate the disability in the face of the mechanical failure.
Any further discussion? All right, seeing none. So the motion on the table it's to be taken together, but it's a split finding. So the motion is to find reasonable grounds for the reasonable modification piece, and no reasonable grounds that there was discrimination based on terms and conditions. If you are in agreement with that motion, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Thank you. This concludes this case. The parties will be informed by letter with the final findings by the commission, along with next steps for conciliation in this case, since there was a reasonable grounds finding. Thank you both.
Right.
Thank you.
We get a 5-minute break, guys?
Sure.
Yeah. Thanks.
5 minutes.
transition to a more experienced real estate attorney, as I told you. I'll push on us that was on my list today, and I was also going to touch with you today as soon as my hearings are done. So, yeah, and it's a court where it's on Zoom, but it just took 5 minutes recess, which I can actually, so I've got to get back on. So I'll touch base with you in a day. Okay, all right, yeah, I'll reach out to them as well. All right, good, thank you. Mark, I see that you just appeared. Are you representing a party in either case? I don't have your name down.
I am. Yeah, good to see you. Good morning.
Good to see you too.
Yes, I am. I'm on behalf of all respondents.
Respondents
in the
okay.
next matter, in the
Got it.
matter.
Yeah, thank you.
Sure.
So I wanted to see that Tom was back. So we'll be in session. Next case is a housing case H250277. Kelly Knickerbocker versus Stevens et al. And the recommended findings are for a finding of no reasonable grounds on both counts. Therefore, we will hear from complainant or counsel.
Mrs. Kelly Knickerbocker, are you present?
I am right here.
Okay. Well, you have 10 minutes. Would you like to reserve any of that time, or would you like to just see what's left over?
Yes, please. May I reserve 5 minutes?
5 minutes, no problem.
Great,
Okay.
thank you.
Begin when you're ready.
Excellent, thanks. Can you hear me all right, or do I need to speak up for you?
No, we hear you just fine.
All right, thank you. So a few comments that I wanted to make was for the discussion of discrimination. The basis for that is arbitrary and inconsistent rule changing. R for the respondent. R had adopted and enforced reactively to and demonstrating favoritism, a lack of consistency with governance. In August 18, 2022, L, I'm going to call L, refer L to our neighbor who had been stated in the claim, had requested a fence modification. That was the original request. They had, I had already had two larger animals. One was a service dog, the other one was a pet. And after declining the fence modification because of ambiguity with who would have ownership moving forward, L then went and petitioned to the board, asking for a new fence rule to be made. And the fence rule was created throughout the next year, despite any documentation of damages. The contrast is that in 2021, I had requested an implementation to a rule that there would be no bird feeders. And this was based off of a $4,000 estimate from squirrel damage in a shared attic space between L and myself. And that was due to 4 bird feeders and a history of bait boxes in L's yard, as well as comments on community forums about needing pest control for rodent activity. And despite the damage, the actual damage estimated, documented, there was no rule that was enacted or changed. And the disparity of treatment and arbitrary rulemaking through R shows that that in their comments it was because of enforced legal costs. But that explanation is only pretextual in the sense that it is they're using it as a different term instead of being discriminatory justification, and they are inconsistent with the enforcement of the HOA rules.
Are you finished?
For that part, yeah.
Okay. Commissioner, questions for complainant? Okay, seeing none, you will have 7 minutes when we come back to you. Okay, and then Attorney Price, you are representing the respondents in this case?
I am, and thank you very much. Thank you all for your
Sorry, would
opportunity
you like
to
to
chat.
reserve any time?
Oh, no reserve for me. Thank you. I don't think I'll
Okay.
take up that much time.
Begin when you're ready.
Sure. Thank you very much for the opportunity to be heard today. And while we appreciate the concerns expressed, we do agree with the factual findings and the conclusions reached through the investigator's report, of course. With regard to the specific concerns raised in this instance today, declaration for the properties at issue, the declaration, Article 9, Section 9.1C. That's a portion of the declaration that makes clear that no property owner may unreasonably interfere with the quiet enjoyment of property by any other property. And so it is not an arbitrary basis for them to have enforced the rules as they have. Even if there was not a rule in place, which we do not concede, the declaration still serves as the operative document from which to derive the board's duties and how to proceed under a given circumstance. The concern conveyed was that the neighbor to the complainant was deprived of the quiet enjoyment of their property due to a dog being large enough to put their front paws on the top of the 4-foot fence. Aggressive conduct was described, the size of the dog is noted, and so it was through a process that the board concluded to meet everyone's needs. The fence needed to be increased in size, and in doing so, they took a somewhat overly accommodative stance and didn't require a complainant to pay for half of the fee associated with that. The board paid it, and then the complainant's neighbor paid the other half. And that's not typically what we would expect to happen here, but this was something done, again, in the interest of just ensuring that the core components of what someone would expect as a property owner were observed under the terms of the declaration. That's all for me on this topic.
Okay, thank you very much. Are there any commissioner questions for Respondents' Counsel? Okay, seeing none. Ms. Kelly Knickerbocker, we come back to you. You have 7 minutes if there's anything else you want to add.
Yes. One of the comments that I had made originally was that they had made several comments about the aggression of the dog, and I had asked that had been removed out of the investigation report as well, because the attorney had said that it was not part of that and there was no supporting documentation to that. And so R is still bringing that up, even though we had discussed that at length with the investigation report, because they said that was not in the actual rule and regulation, and it wasn't attached to it, and it was merely about the size of the animal. And the ADA also said that they can impose restrictions based on the size of the serviced animal, that imposing the rule requires them to have that the size of the animal and the presence of the service dog would not be applicable to someone without the need of the service dog is discriminatory.
Okay. Any other questions from the commissioners for complainant? Okay, seeing none. Attorney Priest, you have 8 minutes and 20 seconds. If you'd like to use
them. Just a brief, brief comment. Attorney Wasson was the attorney who was with me that day and at the conference, and he had made a comment along those lines, but I respectfully disagree with the characterization in that Attorney Wasson had made clear that the behavior is relevant for operation of the rule, but it's not necessary. It's applicable to the investigator's analysis. It's to the motivations for why what happened in terms of the board's actions. And so, yes, all it takes is a dog to be tall enough to, if they put their front paws up on a 4-foot fence, then the rule is going to require that outcome, that the fence height be increased. But when we look at what motivated the decision here in terms of the need for this, the neighbor at issue brought to the board a concern about their ability to safely use and comfortably use their property in line with their expectation of quiet enjoyment. And the dog was jumping up on the fence. These are the core components of the things you look at to determine if someone's quiet enjoyment is being violated or deprived. And so in this instance, what we don't see is evidence of discrimination. We look and we see that this was the reason given, and I'm not aware of any facts to suggest that there is actually pretext here. Again, there's a basis for all of this in the communications that have been submitted as part of the record, and we respectfully submit that there's no cause for changing the outcome here.
Okay, thank you very much. Commissioner, questions for Respondents' Counsel? Seeing none. Okay, so now we will hear from the investigator on this case, which was Angela Morse. Angela?
Hi there, my name is Angela Morse. I'm the investigator that was assigned to this case. I don't have anything further to add, but I'm happy to answer any questions.
It appears there are no questions.
I'm sorry, are we allowed, or is only the commission allowed to ask questions?
Just the commissioners.
Thank you.
And seeing none, thank you, Angela. We've heard from the parties and the investigators, so we'd be looking for a motion here. There are two proposed findings, both no reasonable grounds.
I move to accept the investigator's report as written. One, that there are no reasonable grounds to believe that Mina Stevens, Joanne McComber, Catherine Mitchell, and or Therese LeBoeuf discriminated against Sarah Kelly Knickerbocker on the basis of race, color, and or disability. And number two, there are no reasonable grounds to believe that Mina Stevens, Joanne McComber, Catherine Mitchell, and or Therese LeBoeuf retaliated against Sarah Kelly Knickerbocker for engaging in MHRA protected activity, and that these complaints should be dismissed in accordance with 5 MRS section 4612 subsection 2.
Do I have a second?
Second.
Thank you very much. Is there any discussion? Seeing none. So the motion is to find no reasonable grounds on both counts. If in agreement with that motion, you will vote yes. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
And Commissioner Sanders.
Yes.
Okay. Thank you for everyone's participation. A letter will go out to both parties with the final decision. Thank you for joining. Have a good day.
Thank you very much, all.
Next case is H250291, Stephen Day and Catherine Day versus.
I don't understand. I don't understand how.
Well, you can go and write him, Chris.
Go ahead, Commissioner David.
Day versus Leanne Messina. The recommendation is a split recommendation, including a recommendation for finding reasonable grounds on one count. And I think we'll start with that and therefore recognize a respondent.
Okay, is Mr. Day present?
No, it would be respondent, wouldn't it?
That's me. I'm the Leanne Messina.
I got it backwards. I apologize. Ms. Messina, you have 10 minutes. Would you like to reserve any of that time?
Whatever the max I can get, up to 30 minutes.
10 minutes is the maximum amount of time that you have.
No, everybody else was given 5 minutes after that.
Only if everybody was given a maximum amount of 10 minutes. You were allowed to reserve any of that time within that time frame, and I will stop you. Otherwise, the maximum time is 10 minutes.
Okay.
Okay. Begin when you're ready.
Okay. First of all, I want to confirm procedural things. I want every single bar association number with anyone here.
This is
you know what, sir?
For you to present your case.
No.
It's not a time for you to ask
Okay.
questions.
I actually have a right.
Ms. Messina, you've been muted just for now. Okay, this is your first chance, right? So the purpose of this hearing is for you to present your case, right? From the position that whatever disagreement you have with the report. That's the limit that you have here. If you go beyond that, then you don't have a right to be heard at this hearing. Do you understand?
I do understand. So I have my 10 minutes to say what I want. And right now, yes,
minutes to say your case about.
I am making my case, and you can't tell me how to do it because the Board of Overseers is waiting for this because there are so.
Jane, you can go ahead and unmute her. So you have to keep it to the parameters of your case. Stick to the facts of the case, stick to the investigator's report, and that's it. This is your last warning. If you start talking about things that are extrinsic to this investigation, then that will be the end of your presentation. Okay?
No, there is no okay, because you can't do that. Because what I say, I'll address Ms. O'Neill, but sir, you are in such violation of practicing unauthorized practice of law. And
okay. That's all we've got for you, Ms. Messina.
is the Board of Overseers is waiting, and I will.
That's great.
I will get every single law license. So anybody who's actually.
Okay. All right. Respondents, Mr. Day, is there anything that you would like to present in response to the investigator's report today?
I would basically just like to say that I appreciate the time and effort that the investigator put into the report, and we accept the findings on both counts, and that's all that we need to do on our end.
Okay, thank you very much. Okay, commissioners, sort of heard from both parties in this case. Is there any, well, I guess we should hear from the investigator before we move forward.
Can I just ask, is the complainant on still?
No, complainant got booted from the call.
Okay, thank you.
Complainant has been in
Not complainant, it's the respondent.
Oh, I'm sorry.
That's
I keep
okay.
thinking about it.
Respondent was warned many a time that she should, as our rules provide, stick to the facts and legal disagreement about the case. Our procedural rule, Rule 2, is very specific about what is allowed to be presented at a commission meeting, and disparagement and yelling about our bar licenses is not among the things that is permitted.
Okay, so we've heard sort of from both parties in this case. I'd like to give the investigator a chance to answer questions if you would like. So the investigator here was Carrie McCarter. Carrie, is there anything you'd like to add?
No, my name is Carrie McCarter. I'm the investigator assigned to this case. I don't have anything to add, but I'm happy to answer any questions.
Thank you, Carrie. So are there any questions for the investigator from the commissioners? Okay, seeing none.
Carrie, the reasonable grounds to believe that that respondent retaliated is based on what?
Is based on after the commission complaint was filed, she filed a protection from harassment order against the complainant Stephen Day. And in the reasons for doing so, she specified the commission complaint or proceedings.
So she's retaliating by filing a request for protection from her harassment order after what?
After Stephen Day filed his complaint with the commission.
Oh, the complaint with the commission is the retaliation. Okay. Thank you.
Any other questions from the commissioners? Okay, seeing none. This time we'd be looking for a motion. There are 3 proposed findings.
Well, given the posture that we're in without any presentation because of her own behavior, I would take them together and move that there's no reasonable grounds to believe that respondent discriminated against complainants based on familial status, disability, or religion. No reasonable grounds to believe that respondent retaliated against Catherine Day, and that there are reasonable grounds to believe that respondent retaliated against Stephen Day.
Second.
Okay, there's a second. Is there any discussion? Okay, seeing none. So the motion is to find no reasonable grounds based on familial status, disability, and religion. No reasonable grounds against Catherine Day, but reasonable grounds, sorry, not against, regarding Stephen Day for retaliation. If in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay, thank you very much. That concludes that case for today. A letter will be sent to both parties with the final determination and next steps regarding conciliation, since there was a reasonable grounds finding. Okay, and then the last case.
Last case is, let me get back to my agenda. H250302, Beckett and Jewell.
And
Oh,
Commissioner
no,
David, this
Beckett,
is the-
yeah, Beckett versus Jewell et al.
Right. This is the case that you voted not to withdraw earlier today. Just want to make sure that the complainant is, whether or not the complainant is here and wishes to present their case.
Right.
Is Ms. Beckett here? Okay. So I don't believe the complainant is here. Typically in these situations, the commission would vote to accept the investigator's report finding. Since this is no reasonable grounds recommendation, at this point, I'd be looking for a motion to accept those findings. There's one proposed finding.
Yeah, I'll move to accept the investigator's finding that there is no reasonable grounds to believe that Joyce Jewell, Delane Gillis, and Larry Fowler discriminated against complainant on the basis of religion in violation of the MHRA, and the complaint should be dismissed in accordance with 5 MRS 4612, subsection 2.
Thank you very much. Is there a second? Okay.
Second.
Any discussion? Seeing none, the motion is to find no reasonable grounds, accept the investigator's report. If in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay, thank you very much.
So are we ready for executive session?
I think so.
Yes.
Pursuant to 1 MRSA 4056E, I move to go into an executive session to consult with our attorney regarding pending and contemplated litigation and the rights and duties of the commission. That's a motion.
Yes.
Second.
Sorry, who was the second?
Second.
Thank you. Okay. If in agreement, you will vote yes. Commissioner Douglas?
Yes.
Skipped. Sorry, Commissioner David, I skipped you.
That's all right.
Initials here. So
You skipped a bunch of people, but I dig it. Yeah.
Commissioner O'Brien?
You've been promoted, Tom.
Are you just refusing to ask Ed?
I did ask him. He said yes. Commissioner Walker?
Yes.
Okay. And Commissioner Sanders?
Yes.
Okay, thank you. Sorry about that. All right, now I'm trying to it looks like Jane's creating the breakout rooms. I was attempting to do that myself. Okay, we'll see you in there. Did we lose anyone in the transition?
Haven't seen Julie yet. Or Megan. I know Megan's there. Mark,
It's okay. We don't need to vote on anything. You can just declare us adjourned.
I can?
Yeah.
Oh.
Seems
Okay.
discourteous to do that without
Oh,
saying
there
have
he
a
is.
There she
Mark was
is.
still in the breakout room. Yeah, we lost Julie in the process.
Nope, Julie's back.
Julie's back. Julie is Mark O'Brien.
Oh, speaking of which, oh wait, never mind.
We are missing Mark, though.
We are
have to
missing
mention it.
Mark. See, I just read the first word on there and I thought it was
right.
Mark.
So Mark is no longer a participant. I think he might have accidentally left instead of leaving the room.
Left the meeting.
Okay.
Yeah.
Okay.
Well, happy New Year to everybody. We will declare the meeting adjourned.